Yes, Mr. Majumdar. Hmm. Okay, we'll have it. Yes. Hmm. Let the matter reach. Pass the order. Okay. Let the matter reach. You are praying on whose behalf? Name the council, please. Okay. Hmm. Hmm. The prayer of the council for the petitioner, Mr. P. N. Sera, matter is adjourned for 3 weeks on a date to be fixed by the registry. Hmm. For a week on a date to be fixed by the registry. What's your good name? On the prayer of Mr. P. Terry, council for the petition. Why? Why? Your good name? You are praying on whose behalf? On the prayer of Mr. Sheikh Abdullah, learned counsel appearing on behalf of Mr. M.I. Hussain. Matter is adjourned for a week. As it is stated at the bar that Mr. M.I. Hussain, counsel leading the petitioner, is indisposed. List after a week on a date to be fixed by the registry. Yes. Why? Why do you need the adjournment? Gyasuddin. What's your good name? Submit about that counsel leading the petitioner, Mr. Gyasuddin, is indisposed. As such, seeking adjournment for a week. Parallel, this is the matter. After 10 days on a date to be fixed by the registry. Yes, Mr. Sharma. Matter is pending since 21st of October 2019, and Mr. Anjan Kalita was furnished as a copy of the order. Okay, fine. Just a minute. Just a minute. Mr. Bora and Mr. Sharma, at page 46, the petitioners and their family members, you see, were declared to be illegal migrant under the Deed and IMD Act by the judgment of 23rd of December 2002. Against the said judgment, they preferred an appeal. There are certain delays, and the appeal was dismissed on 17th of October 2003. After the said order, the petitioners preferred a writ petition, WPC 7093/2003. Now, they are agree with the order of the appellate authority. The page number 59, Mr. Sharma. Peruse the impugn order, right? So it was only the 31st of July 2003. That was the order passed by the appellate authorities. Then this order at 7/10/2023, page number 55. Right? It's a order passed in Miss case number 35 of 2003. Against the judgment of the tribunal dated 23rd of December 2002. Now, while the remitting back the matter to the appellate authority on 11th of November 2003, you will see both the orders of the tribunal as well as the order of the appellate authority of 31st of July 2003 was set aside, and the matter was remanded back to the appellate authority. 31st of July 2003 order is not before us. It is only the order of 17th of October 2003 at page 55 is before us. That order is not under challenge. And we do not know what order was passed on 31st of July 2003. It hasn't been annexed in the writ petition. Mr. Bora, what was the order passed on 31st of July 2003? Will you be able to? Where is that order? Huh? But the order is only at page 59. But where is that order? Place this matter tomorrow along with the records of WPC number 7093/2003, disposed of on 11/11/2003. For motion. Yes, Mr. Sarkar. Hmm. 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 But earlier there was an order, Mr. Sarkar. Correct copy of the impugn opinion. Did you place it before the court? Why that order was passed earlier? There is some mistake in the court brief. Now just see at page 15, Annexure A. Page number 15. Kindly read 1-5. Kindly read. Kindly read that order. Page 1-5. Now come to page 16. What is the case number and what is the date of the judgment? And what you have annexed? Now, what is the page 16? It relates to whom? Is it relates to Jatin Das? Read state versus. Page 16. You have Jatin Das. But in the court copy, first copy, it is Kamaikya Das. That is the reason why court passed an order. Burwa. We do not know. It's your petition. That is why court earlier in 2019 pointed out, you have not taken, you have not corrected it, you have not created a defect. Raise this matter for motion only after correction of the impugn annexure A. In the first copy of the first copy of the court file. Just a minute, just a minute. Just. Mr. Sharma, the petitioner received the notice. Through his engaged counsel, he appeared before the tribunal and submitted his written statement. And thereafter, he did not appear before the tribunal, left everything to the concerned counsel. Whether the tribunal passed any order that your personal presence is not required, No, that is not a ground. That cannot be a ground. We understood that you are illiterate. We are understood. Now, after, when did you file the written statement? On which date? You filed your written statement on 2nd of September 2008. And from 2008 till the passing of the impugn order on 30th of April 2011, it did not appear before the tribunal. Then NRC came. Your name did not figure in the NRC. Then you realized that you are declared as a foreigner or illegal migrant. Then you have approached this writ petition. You have filed this writ petition on 4th of September 2019. Even assuming that you have not appeared before the tribunal, you are fully aware that there was a proceeding pending before the tribunal regarding your nationality. But didn't bother. Not India 2008, 2009, 2010, 2011, till 2019 filing of this writ petition into September 2019. Under which provision of law, you just tell us, Mr. Sharma, that such kind of a proceeding needs to be considered. Show us any law laid down by the Honorable Apex Court or by this High Court. First of all, we do not know. What happened? How will you know? We cannot know. Even you do not know. Apparently, the petitioner was aware of the proceeding pending before the tribunal. After filing of the written statement, it did not appear. By whom? Doesn't matter. So, adjournment was taken. He had this petitioner was aware or regularly appearing. He would have filed his written, after filing of written statement, he would have adduced his evidence. So, it is not that the tribunal did not grant you any opportunity. So, what else? If the opportunity, Mr. Sharma, don't make that submission. We will not consider that kind of prayer. Might have. It is your case. Might have been there. Voter list doesn't give you the right unless you are proved. That is the reason why your nationality was challenged somewhere and you were aware about that. Tell us which provision of law will allow such kind of petition. Show us any such judgment of the Honorable Apex Court or of this High Court, if you have. Otherwise, the Honorable Apex Court has laid down the law. Otherwise, very clear. Maybe he cannot run away like this. Show us any reason, valid reason to consider your prayer. Mind that we are sitting here in certiorari, not in other mandamus or core 1, 2 or something else. So he did not bother to inquire from 2008 September till 2019 September, filing of this writ petition. How many years? How many years? For 11 years, right? So let him be like that. As you know, you have learned that during your course of law. Dismissed and nothing else. This is a mockery of law otherwise. You cannot take the help of law in this way, Mr. Sharma. Straight away dismissed. Heard Mr. H. Sharma, counsel appearing for the petitioner. H. N. Sharma. What kind of? Who have to file it? How the lawyer will place the documents unless you place it, filing an affidavit? We do not know, Mr. Sharma. We cannot consider in certiorari like that. Where is the illegality in this order? Kindly show us the illegality in the order of tribunal. If there is no illegality in the order, that is up to you. There was provisions before the tribunal. You could have approached the tribunal in time, even after passing of the order in 2011. You slept of the matter for 11 years. Only when he found that your name did not figure in the NRC, you woke up. Nothing like that. I think sometimes we should be harsh on the people like this. And we cannot deviate from the law. That's why we're saying, we are sitting here in certiorari, Mr. Sharma. We are not in mandamus or co-warrant or something else. Unless you can point out any illegality in the order of the tribunal, then you can understand. Mr. Sharma, then you can understand our order. Heard Mr. H. N. Sharma, counsel for the petitioner. And Mr. Z. Sharma, standing counsel, Home Department, Assam, for the response numbers 2 and 4. Also heard Mr. P. Sharma, additional senior government advocate, Assam, for the response number 3. Mr. Kuli is here. Saw him in the morning. Okay. Mr. H. Kuli. Sorry, E. Pegu. Night counsel on behalf of Mr. A. Standing Counsel, Election Commission of India, for the response number 5. The petitioner herein filed this writ petition. Please take your seats. On 04/09/2019, dissatisfied with the order, with the judgment dated 30/04/2011, passed by learned member Foreigners Tribunal, First Morigaon, Assam, in FT within bracket T, case number 229/2006, whereby he has been declared to be a foreigner under the Foreigners Act 1946. Brief facts of the case is that the Electoral Registering Authority found the petitioner to be a doubtful citizen. And as such, in the voter list, he was marked as doubtful, putting colon the voter. The learned member, sorry, the Superintendent Police Board right don't write right. Refer the matter for determination of nationality of the petitioner to the Foreigners Tribunal, District of Erstwhile, Nagaon. India, 1997. After bifurcation of Morrigaon district from Nagaon district, the said reference was forwarded to the Foreigners Tribunal, Morrigaon, wherein it was registered as FT within bracket D case number 229/2006. Learned Tribunal and Foreigners Tribunal, Morrigaon. Don't write like it. On receipt of notice from the Foreigners Tribunal, Morrigaon, the petitioner filed his written statement. No. Appealed, don't write filed. Before the said tribunal through his counsel on 16/01/2007. And prayed for time to file his written statement, which was accordingly allowed. And the matter was fixed on 05/03/2007. On 05/03/2007, the petitioner also prayed for further time for filing his written statement. Thereafter, the petitioner continuously remained absent, for which the tribunal thereafter since 28/11/2007. 28/11/2007. Yeah, molecular funded event segment. However, on 02/09/2008, the petitioner appeared before the tribunal and submitted his written statement in said FTD case number 229/2006, and also filed a petition number 405, praying to vacate the order of ex parte hearing which was accordingly allowed by the said tribunal for the ends of justice. The petitioner since then remain absent before the tribunal. In his written statement filed before the tribunal, the petitioner submitted that he is an Indian citizen and that his father, Paresh Sarkar, cast his vote in the year 1966 as his name was enlisted in the voter list of 1966 pertaining to number 83 Bokani constituency against part number 63, center number 42, village Lechari Bori with serial number 272 and house number 58. The petitioner also submitted a photocopy of certificate issued by also don't write photocopy. The petitioner, along with his written statement, submitted a photocopy of the said voter list of 1966 of his father. The petitioner also enclosed a certificate issued by the president of Burgaon Gaon Panchayat and another certificate issued by the Gaon of Lechari village. In spite of taking time on several dates, to adduce his evidence and prove his nationality, and further to prove the documents annexed by him in his written statement. The petitioner did not prove them as required under the Evidence Act and under Section 9 of the Foreigners Act 1946. Since the petitioner, in spite of granting several times, did not appear before the tribunal to prove the documents relied by him to prove his nationality. The tribunal, by order, by judgment dated 30/04/2011, considering the materials available before it, declared, appoint a petitioner to be a foreigner as defined under Section 2 A of the Foreigners Act 1946, as he failed to establish his case as required under Section 9 of the Foreigners Act, and came to the conclusion that the petitioner entered into the territory of India within Assam on or after 25/03/1971 from the specified territory of Bangladesh. In spite of said judgment dated 30/04/2011 of the tribunal, the petitioner did not take any step and when he did not find his name in the draft consolidated list for National Register of Citizens within NRC, as on 30/07/2018, he inquired into the matter and then came to know that as he has already been declared as a foreigner by the Foreigners Tribunal, first Morigaon, on 30/04/2011, in said FTD case number 229/2006, he filed this writ petition on 04/09/2019 as noted above. Stating that he is an illiterate person belonging to poor family, and a fisherman by profession, and after filing of the written statement by his engaged counsel, as well as evidence, he failed to contact his engaged counsel, who in the meanwhile fall ill and died of cancer in the year 2016. And because of the same, the tribunal on 30/04/2011 was the impugn opinion declaring him to be a foreigner. It is also submitted by the petitioner that only in the month of July 2019, he visited the office of the Foreigners Tribunal, First Morrigaon, to know about the position of his case. Where he was informed that he has already been declared as a foreigner as per the said judgment dated 30/04/2011. Thereafter, he applied for the certified copy of the said order judgment dated 30/04/2011. The petitioner also stated that Mr. Sharma,
My lord.
Mr. Gunjan Sharma,
Lordship.
when you able to give us the record? This is from Morrigaon.
Lordship. 1 week.
Give us a date. Today is 29th.
29. Okay. 6th of February, Lordship.
Submission के लिए After hearing the submission of the learned counsels for the parties, we propose to peruse the records in original pertaining to FTD case number 229/2006, wherein the impugn judgment dated 30/04/2011 was passed by the learned member Foreigners Tribunal, First Morrigaon, on 30/04/2011, declaring the petitioner to be a foreigner under the Foreigners Act 1986. in view of the above. The respondents in the Home Department. So I'll place the records in original of said FD case number 229/2006 from the office of the Finance Tribunal, First Morigaon. On 8th of February,
Okay.
list according.
Copy of the order may be
Copy of this order be furnished to Mr.
during the course of the day.
Gunjan Sharma, Study Council, Home Department, Assam, for his necessary use during the course of it.
Right. If I may, my lord, I pray for an adjournment in this matter, my lord. Mr. Sattar, the counsel leading the matter for the petitioner, is unable to appear before the honorable court due to some personal difficulties.
What's your good name?
G. Imtiaz, ma'am. G. Imtiaz.
G. Imtiaz.
Yes, ma'am.
Tell us when shall you fix it?
My lord, on the 7th of February.
Not during, since you have the records,
Yes, ma'am.
6th of February.
Yes, ma'am. Highly obliged.
On the prayer of Mr. G. Imtiaz, learned counsel appearing for the petition of Mr. Isetta. List on 6th of February. Records be retained. Records of the consultant.
That's not nice, huh? My lord, जैसे record काम record receipt, my lord. Fix for investigating or hearing.
No, we are considering now, it's a
Yes.
question of hearing will not be there, you'll get a chance.
Yes, sir. Husband is my lord says.
Just a minute. Yes. Mr. Jasimudin.
My lord.
First, please come to your written statement.
Yes. Page 12.
Yes.
Paragraph 4 first, my lord.
No, straight away, read from para 7.
Yes. But paragraph 4 is important because,
Okay, read para 4.
yes, because along with the notice
Okay, read para 4.
that the case is not manageable for not complying with the mandate of the provisions laid down under Section 3(1) of the Foreigners Tribunal Order. The petitioner SP Bangor is bound to state the grounds upon which the opposite has been alleged to be foreigners. But the notice served upon the opposite party does not disclose any grounds as to why the opposite party has been arraigned as foreigners. That particular has not been furnished to the petitioners. This is on the fact. Now paragraph 7, my lord. The opposite party brought up press Khursamari, P.U. Bahalpur in the Sapor district Dhubri, and his father's name is Babur Ali, alias Babur Ali Sheikh. His grandfather's name is Godulu. His mother's name is Burburi Bibi. Now 8, my lord. Father's name of the has been recorded in the voter list of 1959 under Bilisabha Legislative Assembly constituency, the then district of Kolpa subdivision, Dhubri, village Khursamari, 1959, my lord. Then, my lord, paragraph 9. The opposite and his mother shifted to village Sastapara. So, and here, her mother's name record appeared in the voter list of 1971. Now, my lord, paragraph 11. That previously the opposite party resided at village Sastapara of Pukraja, BTD, and during the period of residing here in a great communal rights arise at Boduland and Narsas. The opposite party, along with his family members, took shelter at the village Durgapur under Balijana Sasabani Soranati Sibir, Hoyapuri police station in the district of Bangagaon, Assam. And during the period of living herein, the name of the opposite party is inserted in the voter list of 1997. Well, they are in camp. Then paragraph 12 onwards, the name of the opposite party is in the voter list of 2010, then 2011, then 15, and the paragraph 14 voter ID card also issued to him. Then page 13, during the opposite party during the period of residing at Balijana Sasabani Sibir, he passes the landed property situated village Koimari Larpara under Sijangram Circle, PS Obaipuri in the district of Bangagaon, Assam, covered by Tagno Soenso. Then the petitioner examined himself as DW1, and his one brother also examined as DW2, and his one cousin brother also examined as DW3. That his brother and other family are not foreigners, and no case also registered against them, my lord.
Which are your exhibits?
Yes. Page 641. Sir. This is the voter list of 1959.
Page
Barnagar.
41.
Yes, 42 is Barnagar original, my lord.
Read 42.
Yes, 42.
Babar Ali Sheikh is my brother, my father.
Babar Ali Sheikh is your
Sheikh.
father.
Yes, mother. And Burburi Bibi, 11 serial number, is my father.
Burbuli Bibi,
Is mother, my mother.
Burburi is your mother.
Mother. This voter list is 1959
Hmm.
and relating to
Village,
Kurishamari.
Kursamari.
Kurishamari. Now my left is 43.
Who is your, you have said Omar Bewa is your,
My lord, Umar Baba, it is wife of Gedlu.
Hmm.
It may be a grandmother.
your grandmother.
Yes.
Have you stated so in your
Now
written statement?
those facts are not stated.
Hmm.
Not stated, but
No,
PW3, he stated in his evidence.
that will come later.
Yes. Those facts are not evident because Sabuddin Sheikh, Gudlu, son of Gudlu, Umar Baba, wife of Gudlu. Now we also can see
Hmm.
page 43.
Yes,
Page
43.
44 is the original.
Hmm.
This is NRC, my lord.
Hmm.
Babu Bali Sheikh.
Hmm.
Husband, name of father, Gudulu.
Hmm.
It should be Babu Ali, but there is a typical mistake. Village Kursamari.
So this is relates to
Relates to father.
Babu Bali Sheikh.
Yes, father of the petitioner.
Okay, fine.
Now, page 46,
Hmm.
71 brutal list, my lord.
Hmm.
It is relating to village Sastapara.
Hmm.
While they are shifted to village Sastapara, my lord.
Hmm.
Mother's name is Burburi Bibi,
Hmm.
Babar Ali. It is exhibit 3.
Hmm.
Now 1997 voter list. For the first time, my name appeared.
Hmm.
Well, we are in camp, relief camp.
Hmm.
So Iman Ali, son of Babar Ali, so he on my wife.
Hmm. Kindly read from the top, page 47.
Yes. The slated type couple electoral rolls, Assembly Constitution 34, Obayaburi North LAC, voter list 1997, District Bangaigaon, Subdivision Lot Salvara, Police Station Obayaburi, name of polling station, Balajani Sasabani Sornati Sibir,
Name,
name of village,
number, and-
Durgapur,
listen. Number and name of police station.
polling station, Balajani Sasabani Sornati Sibir,
Hmm.
within brigade, Beta Falkari.
Bedakhalkari. You know what is Bedakhalkari?
Yes,
Don't have to explain.
Bedakhalkari.
Now, what is the name of the village?
Durgapur here,
Durgapur.
Durgapur. It is under Sasabani Sarnati area.
That is not issued
Yes,
because question is the polling station is Balajani Sasapani Saranati Sip.
yes. But we are in camp at Sasabani camp. We clearly stated that we are during the communal rights, we are in the camp of Sasabani Sarnati Sibit. Balijana Sasabani
Did you
Sibit.
prove that by producing any evidence that you were
No, in evidence I stated, my evidence I stated.
from any documents?
The document is not there, but
Okay.
but it is proof here. It is proof here, or that is why Sarnati Sibit it is mentioned.
That is the Saranati Sibir is the
Sibir.
voting polling station.
My lord,
That you are staying in Saranati Sibir, where is it?
Durgapur. It is
Durgapur is
Durgapur village. This is the Sarnati Sibit. It is Durgapur village.
It is Balajani.
Balajani Sasabani.
See, for that purpose, there has to be anyway before that.
My lord.
This anyway, you first finish your, then we'll ask.
Then my lord.
Then what?
Then my lord, next voter list 2010. Here, you also kindly see, village name has been written Balajani Sasabani.
Hmm.
Hello.
Hmm.
Name and polling station, Hapasara, GPOPs. And time to time, polling station change.
Hmm.
Over there, my lord. Then name of village Balajani Sasabani.
Hmm. This is in 2010.
2010. 2010. Then my lord, 2011.
Hmm.
Village Balajani Sasabani.
Hmm.
Iman Ali, Kashiram, Meherjan Bibi, Fadial Jamal, Hasana Bibi.
Hmm. Hmm.
Now my lord, 2015,
Hmm.
page 50, my lord.
Hmm.
It is for village Balajani Sasabani.
Hmm.
Polling station, Apasara GP office, left side.
Hmm.
Iman Ali, my lord, 2321.
Hmm.
His wife, 322.
Okay.
Then my lord, voter ID of Iman Ali. Village town Balajani Sasabani.
Hmm.
Then my lord, sold it. My lord, page 54. of the album.
Hmm. Hmm. Hmm.
Then here passes sample lot of land
Hmm.
while he was in Tornado Sibir.
Hmm.
One is page 54.
Hmm.
He passes the land from one Akbar
Hmm.
Akali Robita
Hmm.
in the year of 1997.
Hmm. You purchased that land when?
It is 1997. 5/6/1997.
Hmm. 3rd of June 1997.
97.
Yes. Then.
Then another purchase in 23/11/2012.
Hmm. Oh.
My lord.
Second purchase in 23rd of November
Yeah.
2012.
12. In this land, I purchased is Koyumari Laharapara. That land situated at that area. Koyumari Laharapara. So those are the exhibited documents, my lord.
Hmm.
And PAN card is there. Finally, Babur Ali. Plus 16. And that's 16.
That's all.
Well, now judgment, Lord's
Now
calculation.
we'll go to that later.
Hmm.
Okay, you want to say judgment? Yes. Where is?
Page 39,
Yes, 30.
reason for determination.
Read.
In this case, no prosecution witness has been examined. But to prove himself not to be a foreigner, OP has submitted his evidence on affidavit. In his affidavit, OP stated that he is the son of Babur Ali, alias Babur Ali Sheikh, and his name is recorded in the voter list of 1959, Exhibit 1, at village Kurisamari, village district Swensu. OP stated that his father's name is also recorded in the NRC, voter Swensu, 1959, Exhibit 2. OP stated that due to election of his father shifted his residence to village Saslapara, district Rubi, and his mother's name, Burburi Bibi, was recorded at the same village in the year 1971. OP stated that due to poverty, OP and his family shifted to village Durgapur, district Chirang in BTD. OP stated that his name is recorded in the voter list of 1997 in Palizana, Sasapani, Saranati Sibir with his wife. OP stated his name is recorded in the voter list of Swensu, village Palizana, Sasapani, exhibit Swensu. OP stated that he obtained electoral photo identity card, exhibit 8. OP stated that exhibit 9 is the name correction affidavit. OP examined Didlu to Abdul Aziz, son of Babur Ali, and Noburuddin, son of Saburuddin. Didlu to submitted voter identity card, cell deed, and affidavit. To come to just conclusion, let me appreciate the evidence on records along with the above mentioned documents to determine the nationality of opposite party. From record, it appears that OP tried to project Babur Ali Sheikh as his father, whose name is recorded in the voter list of 1959. The name of the voter is Exhibit 1 are Babur Ali Sheikh, Sabad Ali Sheikh, Umar Bawa, and Burburi Bibi. Exhibit 2 is NRC voter details, name of Babur Ali Sheikh. This document pertains to village Kursamari under the district of Dhurbi. In Exhibit 3, as per OP, his mother Burburi Bibi is recorded. The voter list pertains to village Sastapara under PS Palisapara of the 1971. In Exhibit 4, 5, 6, and 7, name of OP is recorded with his wife, Tudiron Bibi, in a different village. These are the translated copy of voter list Sensu of village Durgapur. These voter lists are not sufficient to establish linkage with his projected father. Now his name is found as son of late Babur Ali. OP unable to prove that Babur Ali and Babur Ali Sheikh is one and same persons. Date of birth, age of OP's son is 38 years in the voter list of 1997, which probably be the first voter of the OP. Going by this, his age, his name ought to have been recorded in the voter list. So, the OP has not stated anything what happened to Babur Ali and Babur Ali Bibi. Exhibit 3 is the electoral photo identity card of the opposite party. His relation is shown as Babur Ali. These documents rendered itself insufficient unless linkage is proved. Moreover, apart from not being proved and is post-sensu, in this case, his relation name is shown as Babur Ali instead of Babur Ali Sheikh. Exhibit 9 is the name correction affidavit shown in the sensu. An affidavit is not considered as valid piece of documents within the meaning of section 1 and 3 of the Evidence Act. Deductively to Abdul Aziz claim himself as younger brother of OP, OP has not stated anything that he has a brother, namely Abdul Aziz. Evidence of DW 2 and DW 3 are found contradictory, hence trustworthy. Exhibit 11 is a cell deed 9/6/1990 in the name of Iman Ali. DW 2 submitted his voter ID, wherein his relation name is recorded Babur Ali instead of Babur Ali Sheikh. Therefore, render itself unbelievable. This evidence shown by DW2 explaining discrepancies of name in the voter list cannot be considered as valid piece of evidence that a individual has failed to submit any supporting supporting linkage between individual two and OP. None of the documents submitted by individual two is proved in according to the procedure of law. So, my lord, those evidence
Yes.
not denied, not disputed by the state, my lord, not disputed, and even not cross-examined those witnesses by the prosecution. Prosecution has not also produced any evidence to demolish the evidence entered by the petitioners. Normally, as far as the voter list are concerned, his brother's name and father's name is shown as same, my lord. And he specifically stated in his evidence that he is my elder brother. That fact is also not disputed by rendering any evidence by the state. So, evidence rendered by the is to be hold and field. It is not demolished by the prosecution. Now, my lord, let's back and see the voter list. We are in relief camp so many years. Right taking place from onwards 1983 in BTD area, then 89 also. And time to time, there's things are happening in the BTD area. So, necessarily their name should not be appeared in period to any other voter list. Maybe his name will be appeared if they are living in Sastapara. But they are under those are affected area. So that is why they are living in relief camp. So while they are in the relief camp, their name has been first time appeared in the voter list. And while they are in the relief camp, they purchased some land, some different places. And since his brother and mother, father are not foreigners, so question of petition does not arise, my lord. Because one brother is not very Indian and another brother is foreigner. It cannot be, my lord. As far as discrepancy's name is concerned, my lord, the Sirajul Haq and Supreme Court judgment and Matali, Mutur Rahman, Mutur Rahman, Mutur Rahman. Attesting as intact. Now, Mutur Rahman, and PW2, my lord, he clearly stated that he is my own brother. That has also not denied that I am not the brother of PW1. So section 51 of the Evidence Act is to be taken. My lord. As per section 50, judgment and then Sudhavali case, my lord, that point also discussed. Once a relationship, he can prove that he is my brother. My relationship has not been disturbed and denied by the prosecution. So they cannot, now at this stage, they cannot say that I am not the brother of PW2. They cannot say. And this court also taken to note.
Which brother proved that you're that
PW2,
PW?
my own brother.
By which document?
Yes, he has exhibited his voter ID.
Hmm.
Voter ID, and his father's name has been reflected. That document is not with me, my lord. And one voter list, his name appeared. Huh? Well, nine. Huh? Mucho lo mantengo. Huh? Mucho lo mantengo.
Anything else?
Allora,
We have lots of other motions.
allora. So, allora, I clearly proved that I am the son of Babur Ali. And so the name this is concerned, my lord, proved as the Motiur Rahman and Sirajul Haq.
Okay, you give us the citation.
Yes.
We just,
The-
from the evidence, we want to know from
It is-
something from you. Your projected father is
Babur Ali,
Babur Ali
Babur
Sheikh,
Ali Sheikh.
son of Gadlu.
Hmm.
Gadulu, and your mother's name is Bhurbhuri Bedi,
Bibi.
right?
Yes,
That's your projected father. You said that India 1959, name of your projected father and mother
father.
Father
Yes,
and mother.
Mother.
are reflected in the voter list of 1959 from village Kursamari
Original village.
and district Gwalpara
Hmm.
under Bilasipara police station. Now you have exhibited the NRC of 1959 to show that Baru Ali Sheikh is your father. His name is reflected.
It is normally written Babur Ali, Babu Ali.
India 1971, your name of your projected mother reflected in the village Sastapara,
Sastapara.
522 Sastapara.
While it shifted.
After shifting. Now, for the first time, your name figured in the voter list of 1997
97.
from village Durgapur, village to Durgapur, wherein you have been shown as 38 years,
Yes.
along with one Todiran Bibi,
His wife.
your wife. Now, if in the year 1997, you are 38 years old, what is your birth year?
1959 around maybe.
1959.
59.
In which year you was eligible to vote? 1980.
80,
You add 21
yes.
because at that point in time it was
At
21
21.
years. So you are eligible to vote in the year 1980 and your name figured for the first time in the voter list of 1997. After how many years?
16 years.
How come? After 17 years. And in between, lots of elections took place.
Yes.
Now, your exhibit 4, just you have read. Exhibit 5, Exhibit 6, Exhibit 7. Now, page number 9, page number 47. You read at the top.
Yes. Police station Obayabari, now known and name of polling station.
Above, first of
Balagan
all,
is-
what is written here in the type copy?
Yes, the translated election so
Translated copy of electoral
rules.
electoral.
Assembly constituency 31st Obayabari,
Now, down below,
district Bongaigaon.
is there anything certified to be true copy? As required under section 76, whether the translated copy of any voter list can be considered as the certified copy of a voter list?
Yes, my lord. It is, my lord, it has been prepared on the basis of original.
Now,
On the
kindly
basis,
read
it is their responsibility, my lord. It is
Fine.
not our responsibility and they sign it,
to be an
election
evidence.
officer.
That's right. To be an evidence under section 76 of any public document. Kindly read section 76 of the Evidence Act.
Evidence sector, ana nai? Ana nai? Evidence sector. Evidence sector. Apa bisa? Evidence sector. Evidence sector.
Here, kindly read, Mr. Ahmed.
Hello.
Here, read section 76.
Yes. Seventy-six.
Read very slowly.
Certified copies of public documents.
And voter list is a public document.
Public documents. Every public officer having the custody of a public documents, which any person has a right to inspect, shall give that person on demand a copy of it on payment of the legal fees, therefore, together with a certificate written at the foot of such copy that it is a true copy of such documents or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name, his official title, and shall be sealed whenever such officer is authorized by law to make use of such of a seal, and such copies so certified shall be called certified copies. Explanation. Any officer who by ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of such documents within the meaning of this section. So, my lord, we applied for the certified copy.
We'll see to that. Now, for that purpose, you come to page number 42. Of your read
Yes,
petition.
yes, 42.
Down below, you have seen something?
Yes.
What is that?
Here, election officer signature is there.
As what?
Election officer Bilishipara,
Above that,
above certified to be true copy.
there is also a sentence.
Yes.
Certified to be true extract from the electoral roll of the above mentioned constituency,
Yes.
revised with regard to 1959 year as the qualifying date as in force on the date of issue of this certificate.
Certificate.
Certified to be true copy, election officer Bilasipara.
Sure.
Now come to page number 46.
Yes. Same thing is there,
Same thing is there, and
Yes.
specified, certified to be true copy.
my lord.
Now, at page number 47, 48, 49,
My lord.
50,
My
is
lord.
there anything where it was specified that it is certified to be true copy as required under section 76?
It is not there,
It
but
is not there.
My
When it
lord.
is not there, Mr. Jasimuddin
my
Ahmed,
lord, my lord.
when it is not there, we cannot go beyond section 76.
My lord, then the loss may call explanation from the officer or
We are
issuing
not on
authority.
that. It is your document to prove.
My lord. Why they are,
Now,
we applied, my lord.
Don't, at
Yes.
this moment, these things are not there before us, right? Whatever before us, we are only pointing out to you. Now, come to the cross of your two witnesses. DW2,
Page 35, my lord.
come to page 30,
36.
30. This is your projected brother whose
Correct.
name you did not mention in your
Abdullah.
written statement.
Yes,
In your written statement, you are totally silent. How many siblings you have,
yes.
their names, nothing.
Got it.
Now, here is DW2, who is your projected brother. Kindly read the cross of said DW2.
These are actually not crossed by the authority.
that was-
It is a court question.
Court question.
Yes. court
What
question.
is it? Yes.
বিপৰীত পক্ষ মোৰ ডাঙৰ ভাই হয় তেওঁৰ বয়স 56 বছৰ তেওঁৰ নাম ভোটাৰ তালিকাত কেতিয়া উঠে মই নাজানো মোৰ দেউতা চাপৰ থানাৰ অন্তৰ্গত কুৰচামাৰী গাঁৱত মৰিছিল থাকিছিল মোৰ দেউতাই প্ৰথমে কেতিয়া ভোট দিছিল মই নাজানো মোৰ আৰু মোৰ দেউতাৰ নাম কোনো ভোটাৰ তালিকাত একেলগে নাই মোৰ আৰু বিপৰীত পক্ষৰ নাম কোনো ভোটাৰ তালিকাত একেলগে নাই বিপৰীত পক্ষ আৰু মোৰ দেউতা নামো ভোটাৰ তালিকাত একেলগে নাই মোৰ ভাই বালাজানি গাঁৱত কেতিয়াৰ পৰা থাকে মই নাজানো কোচামাৰী গাঁৱত বিপৰীত পক্ষৰ নাম ভোটাৰ তালিকাত নাই কোচামাৰী গাঁৱত তেওঁৰ নাম বালাজানি গাঁৱত তেওঁৰ নাম ভোটাৰ তালিকাত কেতিয়া উঠে মই নাজানো 2011 চনৰ মোৰ ভাই অৰ্থাৎ বিপৰীত পক্ষৰ লগত একেলগে নাম থকা
হাসনা বিবি
হাসনা বিবি বেগম কোন মই নাজানো বিপৰীত পক্ষৰ ঘৰত কোন মানুহ বাস কৰে মই নাজানো
He doesn't know the family members of his own brother. He doesn't know his Hasna Bibi whom we are projecting that
Because,
your wife.
well
Fine. Next, come to the
then while they are
come to page 36.
while they are in Shibir, then they are living separately, my lord. That is right. Iman Ali more জেঠাৰ ল'ৰা হয়
Here this is your cousin brother,
cousin
according
brother
to you.
নবৰি
Right.
জেঠাৰ ল'ৰা মই বালাজানি চাচাপানী শৰণাৰ্থী শিবিৰত কিমান
no.
বছৰ আছিলো মোৰ
No,
মনত
no,
নাই
no, there is a sentence. Iman Ali Mur Jathal Lora Hoy.
হয়
Next.
মই সেইটো জেঠাৰ
Next.
ল'ৰা হয় তেওঁৰ বয়স ইমান বছৰ
58
বছৰ মই বালাজানি চাচাপানী শৰণাৰ্থী শিবিৰত কিমান বছৰ আছিলো মোৰ মনত নাই শিবিৰ শৰণাৰ্থী শিবিৰলৈ অহাৰ আগতে বিপৰীত পক্ষ বেংটলত আছিল
Now he is stating that you stayed at Bengtol prior to coming to the center.
শিবিৰ
Yes.
Civil.
Then
বেংটল এণ্ড ষষ্ঠপাৰা ইজ মাই নিয়াৰেষ্ট
we do not know. Yes. Then
বেংটলত কিমান বছৰ আছিল মই নাজানো বিপৰীত পক্ষৰ জন্ম চাপৰ থানাৰ অন্তৰ্গত কুষ্টাকাটা গাঁৱত বিপৰীত পক্ষই প্ৰথমতে কেতিয়া ভোট দিছিল মই নাজানো কিন্তু এইটো জানো যে কুষ্টাকাটা গাঁৱত দিছিল বিপৰীত পক্ষৰ দেউতাক প্ৰথমতে কোন চনত ভোট দিছিল মই নাজানো। মই প্ৰথমে কেতিয়া ভোট দিছিলো মই নাজানো। মোৰ নাম আৰু বিপৰীত পক্ষৰ নাম কোনো ভোটাৰ তালিকাত একেলগে নাই। মোৰ দেউতা আৰু বিপৰীত পক্ষৰ দেউতাৰ নাম কোন ভোটাৰ তালিকাত একেলগে নাই। It may not be because they are living separately. How their name come jointly? They are living separately. And even in Sovereignty Civil, more than 15 years they are in Sovereignty Civil. So how can they know that their name appear
Now,
where?
please come to the voter list of 1997 where your name for the first time
Yes,
recorded.
yes, 47.
You read page 47 again.
Again. Translated copy of
Forget that
electoral
one.
roll.
District.
District Bongaigaon, Subdivision North Salmara, Police Station of Bayapuri, name of polling station 110 Balajani,
Mm.
Chasapani, Sonati Sibir, Bedekhalgari, name of village number 2, Durgapur.
This is your village.
Two villages there, one Chasapani, Balajani Chasapani,
That is not
another
there in
two.
the certified, that is not in the voter list.
No,
It is say number 2 Durgapur,
Durgapur.
right?
Yes.
Now you plus come to page 54, your exhibit 11.
Yes. Soslapara. He written.
You read
Yes.
Borabar.
बराबर इमानुअल अली शेख, पिता मित्र बाबुर अली शेख, जाति मुसलमान, पेशा की सांग ससलापारा, थाना सापर,
Sobre.
सब रेजिस्ट्री बिलासीपारा, सदर और जिला धुबरी.
Now, see, there is a voter list of 1997 where you have been shown to be a resident of village Durgapur under Abhayapuri police station, subdivision North Salmara. At the same time in the year 1997, a person known as Iman Ali Sheikh, son of Babur Ali Sheikh, shown to have been shown as a resident of Saslapara, police station Sapor, under Bilasipara subdivision.
Southern district Dhubri. It is his original village, my lord. That is why they ran his original village.
If it is his original, we are not on that.
Saslapara.
Mr. Ahmed, what we are asking you is to show that at the same time, his name has been shown to be a resident of this village. And at the same time, he
Because
have also purchased.
because when enumeration going on is
There is a
1997.
difference. That is the difference we have already read to you.
Yes.
Pita Mrito Babur Ali Sheikh, and at voter list of 1996, 7, Iman Ali, one Iman Ali, son of late Babur Ali.
Yes.
Whereas that cell deed is of one Muhammad Iman Ali Sheikh, son of Babur Ali Sheikh. Yes, Mr. Sharma.
Then my next document, Babur Ali, it is written as Babur Ali, Iman Ali, son of late Babur Ali. Case 58.
Hmm.
57. So those documents are exhibited.
Hmm.
Because here village written is Saslapara, his original village.
Hmm.
And when his name appeared in 1995, well, they are in camp.
Hmm.
That is why then innovation going on, their name has been recorded.
Then
And mentioned
where?
as Betokalgari.
Hmm.
Betokalgari is mentioned, that is why.
Then where you have shifted?
My lord, then thereafter now we continuously then Balijana.
Hmm.
Now then earlier we Kursamari, then Sastapara.
Hmm.
I will tell some judgment, my lord, regarding the name just given his of yes. And there are one Sujabali, my lord, copies noted number 2 there. And one WBC number, my lord, copy is not. Yeah, what number two? Number WBC number? Hmm? Itu. And WBC number 222221/2020.
WBC number
2221/2020.
2221.
Yes.
Hmm.
2221/2020 Soja Valley.
Okay, then
Then, my lord, WBC number. I give the copy on Motir Rahman, it is reported. And Sirajul Haq.
Motir Rahman reported where?
What copy did you learn? What there? What copy did there? What are you going to I forwarded a copy, my lord. Motir Rahman. And Sirajul Haq to there. What will pass out at the time? Wait a second. Kalau Roman semester, kalau muncul kalau Roman, malam ini iot malam. Itu dargan tu sih. Itu sudah dargan tu sih. Itu kan dargan. Apa itu? Oh, itu. Itu ni sah. And Sojavali also devoted, but he was like,
Yes, give us the citation first. There are other cases.
Sirajul Haq I will given, my lord. Reported in 2019, 5.
That we have received. What is the
Yes.
other two cases that you have? relied on?
Other copies, my lord.
One is Motir Rahman, one is Sirajul Haq.
Sirajul Haq. One
And
is
the other case is WBC.
Sojavali.
Sujawali is 2221.
Yes, 2020.
Fine. Yes.
Then, my lord, one copy I will give Mustafa Ahmed regarding affidavit, my lord. This could hold that affidavit is a piece of evidence. It can be accepted. I will punish that judgment. And another
As per the sections, as per the provisions of the Evidence Act,
act,
it is acceptable.
accepted. And
Which provision of Evidence Act? Can you tell us?
I will fill that judgment, my lord.
Hmm.
Fill the judgment.
What is the name?
Mustafa Ahmed and others.
MUS?
Mustafa, MUS, Mustafa Ahmed and others.
Hmm.
And later on, he was expired. His legal affairs represented that case. Then it was held that it is acceptable. Then, my lord, then in Sujavali cases, some judgment has been deferred.
We'll look into that.
It is there, my lord,
We'll look into
regarding section 50 and relative evidence, proof of relationship. If it is not denied, not disputed, then it should be accepted. And the learned court below should discuss the same, whether he is my brother or not. But that part is not totally missing. That is why suitability has been remanded back to the court below for redetermination.
Did
I-
you mention how many siblings you have, how many paternal uncles you have in your
It
written
is,
statement?
there is not mentioned, tribunal they are not mentioned,
No, in your written statement, did you mention?
not mentioned. That is why.
Yes,
That
Mr.
is-
Sir.
Yes, Lordship.
So Mr. Ahmed also.
Lordship,
Say you have seen, first of all, that name of his father, his mother, reflected in the voter list of 5971.
yes, Lordship.
His two witnesses
Yes,
adduce evidence on his behalf,
yes, Lord.
shown the relation.
Yes,
He is saying that it is an acceptable piece of evidence which has not been considered by the tribunal. So,
my lord, my humble submission is that Lordship, at first petitioner has relied on voter list of 1959 of village Kusamari,
Kursamari.
yes, Lordship. And then Lordship NRC document which is not acceptable evidence, Lordship.
Some person in the name of Babar Ali Sheikh,
Yes, Lordship.
right,
Yes,
was there
yes,
in the village Kursamari,
yes, Lordship.
son of Gadulu, whom the petitioner is projected as his father,
Father, Lordship,
and one Bhurburi Bibi
as his mother.
as his mother.
Lordship, after that, after 1959 voter list, Lordship, petitioner relies on voter list of 1971 of different village, Lordship.
Hmm.
And Lordship, although in written statement, petitioner stated that he has shifted due to his livelihood, Lordship, from village Kusamari to Sastrapara, that was not proved. No, otherwise, Lordship, shifting has to be proved by the petitioner, Lordship.
So according to you,
Yes,
shifting has to be proved.
yes, Lordship. And in this case, Lordship, petitioner could not able to place any document regarding his shifting,
Now,
Lordship. Only
Which
or-
judgment says that shifting have to be proved?
Lordship. At present, I don't have that. I will provide the same, Lordship.
Okay, provide us at 2 o'clock.
Lordship. Yes, Lordship.
Then,
Lordship, petitioner relies on after 1971, Lordship, petitioner relies on voter list of 1997. What happened to in between voter list are not there, Lordship. So, Lordship, a continuity was not proved. As per section 6A2 of the Citizenship Act, Lordship. After 1997 voter list, Lordship, petitioner was first time his name reflected at the age of 38 years. And Lordship, village is also different, Lordship, in this village Durgapur, Lordship. So, by placing this voter list, Lordship, petitioner could not establish his link with the person named as Babar Ali Sheikh, whose name reflected in the year of 1959, Lordship. Then, Lordship, in between them, Lordship, then Lordship 2010 voter list, petitioner states that due to communal riot, he has shifted to that village named as Durgapur, Lordship. And Lordship, one witness, Lordship, DW3. He stated in his deposition that, Lordship, before Durgapur, Lordship, petitioner was continuously living at village Bengtol, Lordship. And regarding that village, petitioner was silent.
nowhere in his evidence as well as written statement petitioner stated that he was sometimes residing at village Bangtol. Lordship, after that, Lordship, so Lordship, if we see the voter list of 1959 to 1957, petitioner's father's name is Senjing from Babur Ali Sheikh to Babur Ali. And regarding that petitioner
Sworn an affidavit.
sworn an affidavit, which is not acceptable in evidence, Lordship. Regarding that, I want to place the judgment of dishonorable court, Lordship, 2751 of 2019, WPC 2751 of 2019. Page, para 12, Lordship.
2791
Yes, Lordship.
of 2019.
2751 of 2019.
Hmm.
2751 of 2019.
Disposed of on
Para 12, Lordship. Dispose of on, Lordship. 4/5/2019.
kindly read. There are 12.
The petitioner had sought to clarify the discrepancies found in respect of the names of her projected father by submitting a self-sworn affidavit. It is a settled legal proposition that an affidavit is not evidence within the meaning of Section 3 of the Evidence Act 1872. Affidavits are not included within the purview of the definition of evidence. It is held in Ayub Khan, Nur Khan, Pathan versus State of Maharashtra and others, 2013 4 SCC 465, that the filing of an affidavit of one's own statement in one's own favor cannot be regarded as sufficient evidence for any court or tribunal on the basis of which it can come to a conclusion as regards a particular facts or situation.
What is the SCC submission?
Lordship, 2013 4 SCC 465.
Okay.
2013 4 SCC 465.
There is also provision in the CPC and the Evidence Act,
Yes, Lordship.
order 1012, I think so.
Yes, Lordship. And Lordship, regarding Lordship, petitioner states that State Authority did not raise any objection in respect of his claim, Lordship. Regarding that, Lordship, law has already been settled by this honorable court that in the case of State of Assam versus Ohabali, Lordship, WPC 2641 of 2017.
2641.
Yes, Lordship. 2641 of 2017, Lordship. Here, Lordship, para 16. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mandal, reported in 2013 1 GLT 809. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never saves. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevancy to the facts in issue. By mere filing of documents without examining each admissibility and without documents being proved, without examining each relevancy, it cannot be said that the proceeding had discharged its burden. Question of rebuttal evidence by the state will arise only if the proceeding adduces evidence which are admissible, proved, and which are relevant. And regarding rebuttal evidence, Lordship, Sarbananda Sonowal's case also reflected in para 26, Lordship. Para 20, may I go to Lordship, para 26? There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give his evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes place of birth of his grandparents may also be relevant, like under section 6A 1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on this on these points, the state authorities can verify the facts and can lead the evidence in rebuttal if necessary. Lordship, if the state authorities dispute the claim of the citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. And voter list placed by the petitioner, Lordship, cannot be accepted as valid piece of evidence, Lordship, to prove his linkage, Lordship. Although link was not established, Lordship, with his projected father. Lordship, regarding that, Lordship, I want to rely on decision of this court, Lordship, WBC 7669 of 2016. 7669 of 2016.
7669,
Yes, Lordship.
2019.
16, Lordship. Burhan Ali.
Yes.
It was decided on 8/6, 2018. I want to rely, Lordship, from paragraph 21.7, Lordship. From 21.6, Lordship. From 21.5, Lordship. That bring us to section 76 of the Evidence Act. Every public officer having custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees. Therefore, together with a certificate written at the foot of such a copy, that it is a true copy of such document or part thereof, as the case may be, and as such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. As per section 77 of the Evidence Act, such certified copies may be produced in proof of contents of the public document or part thereof. Therefore, if a proceeding relies on a voter list, only certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned, unauthenticated, or uncertified copy of voter list sought to be relied upon as a proof of citizenship would not be admissible in evidence. Therefore, we would respectfully disagree with the view taken by the Orissa High Court. There is one more aspect. Though under Section 79 of the Evidence Act, there is presumption as to the genuineness of certified copies, provided that such documents is substantially in the form and purports to be executed in the manner directed by law. In that behalf, it is in the public domain that citizenship is a continuous issue. Insofar the state of Assam is concerned, there are 100 foreigners tribunals functioning in the state of Assam which are mandated under the law to answer the reference made to them by the referral authority. That is the concerned superintendent of police border as to whether the proceeding is a foreigner or not. Simultaneously, process is on for finalizing or rather updating National Register of Citizens in the state of Assam. In both the processes, proceedee or claimant, as the case may be, primarily rely upon voter list to prove their citizenship. It is also in public domain that a large number of voters lists have been detected which have been suspected to be not genuine. Therefore, notwithstanding the presumption of genuineness under Section 79, it would be safe for the tribunals and the courts to insist on proof of contents of such certified copies by comparing with the primary evidence, that is, electoral roll in original, produced and testified before the tribunal or the court by the lawful custodian of such primary evidence, by the concerned electoral registration officer or by his authorized officer or personnel.
From this judgment, what do you want to place?
Lordship, certified copy placed by the petitioner lordship.
What?
Placed by the petitioner lordship is not in accordance with Section 76 of the Evidence Act, lordship.
What else?
Yes, lordship. And lordship, apart from that, lordship, and lordship, and certified copy of voter list is needs to be proved, lordship. And as per this order, lordship. Again, lordship, and lordship. Now, okay, John, I have placed before your lordship one judgment of this honorable court, lordship WBC 1073 of 2016. Document. We appreciate the well, lordship, law has been settled that document has to be appreciated as a whole, lordship, not in part. Abdul Quddus case, lordship. WBC 1073 of 2016.
Okay. Mr. Ahmed, and Mr. Sharma,
Lord,
short written argument by both of you, along with the judgments that you want to rely. What is on Friday? We are fixing it on
Yes.
Friday. You submit your written arguments along with your.
Before that, I one section 65 of the Evidence Act and 65B, admissibility of electronic records. It is there, my lord. Now, Mustafa Ahmed, I got the judgment. Paragraph 15, it is mentioned. And now Hyder Ali. And Hyder Ali reported in my lord. 2021.
AIR,
No, it is vote 2021 3 GLT,
2021, 3
3
GLT.
Guwahati Law Times GLT 85.
Okay.
And also AIR 1991.
Okay.
And here regarding paragraph, my lord, very important one, 21, 22.
Hyder Ali or Mustafa?
Hyder Ali.
Paragraph
21, 22, 24, 26 regarding statement non mentioning the whole, it is not necessary. 26, 26.
we'll look into it.
Yes.
Mr. Sharma, kindly note down the judgment cited by Mr. Ahmed
Yes, Lord.
and place your written arguments on Friday along with
Yes,
the
Lord.
judgment that you relied on.
Yes, Lord.
And 33 also.
Yes. Heard Mr. J. Ahmed, learned counsel appearing for the petition. And Mr. J. Pegu, standing counsel, learned counsel on behalf of Mr. A. I. Ali, standing counsel, Election Commission of India, for the response number 2. Also heard Mr. Z. Sharma, standing counsel from Department of Assam, for the response number 3, 6 and 7, as well as Mr. P. Sharma, additional senior government advocate Assam, for the respondent number 5. We have perused the records of Bongaigaon FP case number 1391 of 2007, wherein the Foreigners Tribunal Bongaigaon number 2 of Vayapuri passed the impugned judgment in order dated 09/01/2020 declaring the petitioner to be a foreigner under the Foreigners Act 1946. Foreigners Act, an illegal migrant of post 25/03/1971. Both Mr. J. Ahmed, learned counsel for the petitioner, and Mr. Z. Sharma, standing counsel from department, shall submit their short written argument along with the relevant judgments relied by them in support of their submission. List on Friday. Lovely day to Friday. Second.
গোটেই ৰাতি খাই দিলা
You know,
এই
Rabia Patan.
এইটো কিবা আৰু এটা ডিছপ্ৰগ্ৰাম আছে ন এটা ডিছপ্ৰগ্ৰাম আছে এটালেই না হতো ডাবল ডাবল টেস্ট
Heard Mr. A. M. Ahmed, counsel appearing for the petition. And Mr. J. Pine, standing counsel, Home Department, Assam, for the respondent number 2 and 4. Also heard Mr. P. Sharma, additional senior government advocate, Assam, for the respondent number 3. As well as Mr. J. Pegu, right? E. Pegu. Z, huh?
T, my lord. T.
T.
Yes.
for Tamil Nadu.
Full name Tanuj. Anuj and Tanuj.
Tanuj.
Do you know meaning of the Tanuj? You have heard Tanuja. You have heard Tanuja. You know about her. Who is she? Now, what do you mean by Tanuj? You know Ograj? Who is Ograj?
Senior. Senior.
Is telling you, senior. Who is Anuj? Junior.
Junior.
Then who is Tanuj? You are Tanuj, right? You don't know the meaning of Tanuj. Go to library and see the dictionary, Assamese dictionary, right? You have hard tan man dhan. Hard tan man dhan. What is tan? Go to the dictionary, go through the and find out. You have a beautiful name, you should know the meaning. Epegu. On behalf of Mr. AIL, Standing Council Election Commission of India. Press for number 5. Before proceeding further, we like to peruse the records of BNZNFT case number 2722/2007. Disposed of on 01/06/2016 by learned member Foreigners Tribunal, Bongaigaon, number 2 at Puri. As well as the record of the case number BNZN/FT-2/APR/36/2017. Disposed of on 28/09/2021 by the learned member Foreigners Tribunal, Bongaigaon, number 2 of Puri. Also by learned member Foreigners. Where in both the FT cases noted above, The petitioner has been declared to be a foreigner under the Foreigners Act 1946. But illegally entered into territory of India, Assam. From foreigner or illegal migrant visa. The territory of India on Assam on or after 25/03/1971. Will you able to produce the records, Mr. Payeng? This is both from Abhayapuri, Bongaigaon.
Yes.
When okay, registry shall call for the
Yes, yes.
records of
Registry-
case number for it.
আমি intimate করে দিব লাগলে
Registry shall call for the records of this and list the matter for motion on 13th of February. Or don't make it 30th, make it 15th of February. List according.
Oblige.
May it please the lordship. Lordship, your lordship will find the impugned order from page 71, your lordship. May I take your lordship to the relevant portion of the order, your lordship, wherein the evidence were appreciated, your lordship. It is from page 78, your lordship.
Heard Mr. Hussain, counsel appearing for the petition. And Mr. J. Payeng, standing counsel, Home Department, Assam, for the response number 2 and 6. Also heard Mr. T. Pegu, Learned Standing Counsel, Learned Counsel on behalf of Mr. A.I. Ali, Standing Counsel, Election Commission of India, for the response number 3, as well as Mr. P. Sharma, Learned Additional Senior Government Assam, for the response number 5. On a reference being made by the Superintendent of Police Border, Tezpur, Sonitpur, Tezpur, Hide number TZP, within bracket capital B oblique 10 oblique 1588, dated 14/05/2010. The learned member of Fairness Tribunal 1, Tezpur. In case number FT 1723/2012. After hearing the petitioner, and considering the evidence adduced by her, and after hearing the opposite parties, by the impugned opinion dated 19/09/2023. Opined the petitioner to be a foreigner. Under the Foreigners Act 1946 or post 25/03/1971 stream. Dissatisfied with the said opinion dated 19/09/2023. The petitioner has filed this writ petition on 21/12/2023. Issue notice returnable by 8 weeks as such and such, no formal notice. Petitioner shall have requisite extra copies by tomorrow obtaining necessary acknowledgement from those learned counsels. Obtaining necessary acknowledgement provided. Petitioner shall have requisite extra copy of this writ petition, including the annexes appended thereto, to Mr. R. K. Dev Chaudhary, learned Deputy Solicitor General of India, obtaining necessary acknowledgement from him for the response number 1. And further shall take steps on the response number 4 by register post OJD. providing its correct and proper address with requisite postal stamps. Or as well by tomorrow. This notice returnable by this leaks in okay? Call for the records of practical. Council steps. Subject to taking steps on the respondents as directed above. And subject to her appearance before the Superintendent of Police Board, Sonitpur, Tezpur. Sonitpur at Tezpur. On or before 15th of February. Or make it 13th of February. The petitioner shall not be petitioner if in the meanwhile she has not been taken into custody pursuant to the impugn opinion dated 19/09/2023. She shall not be taken into custody and shall not be deported from the territory of India. As the petitioner has already been declared as a foreigner by the Foreigners Tribunal number 1 Tezpur Assam, Tezpur, by the impugn opinion 19/09/2020. On her such appearance before the Superintendent of Police Board at Tezpur on or before 13/02/2024, the said authority Ekini Rupamba protected. Registry shall list this matter according on receipt of the 11 reports from the concerned foreign staff system.
Right.
Yes, Mr. Abbas,
Lordship, it's a contested matter, Lordship.
what is the opinion?
Opinion on page 83, Lordship. That's from 83, Lordship. The reasons mentioned, page 89 onwards, Lordship, why she has been declared foreigner, Lordship. She exhibited bodily since 1963.
They have asked for the petition. Or Mr. T. Pegu, Planet Council on behalf of Mr. A. Ali for the opposite arrest of arrestment number 2. J. Pine, standing council 3 and 5. 3, 5, 6. Mr. P. Sharma, additional for arrestment number 4. Impugn order dated 30/11/2022. As well, I remember for an tribal Kozali Assam. Inactive case number 1847/2018. Similar order, huh? Court project. Same query.
Lordship, in this case,
If we are before superintendent, whether he is in custody,
no, Lordship.
it is stated by the petitioner.
SP Baksa will be appropriate because now record has been come to the Baksa because village is now under the jurisdiction of Baksa.
30/11/2007. The petitioner has not even taken into custody. Petitioner appeal before. Just a minute.
Respondent number 6, I think. Lordship.
This is the first page of the opinion, page number 83.
Yes, Lordship. First page, Lordship. The reference was made by the SP Board of Borpeta, Lordship. Subsequently, since
As the, no, because no village, nothing, that's the reason.
oh, Lordship. On this one provided because of it, if you Lordship see the delivery of date of delivery
If we
application.
are before Superintendent of Police Board or Baksa. On or before same date. Call for the records from. Bozali is still there, Mr. Pegu, Mr. Pine?
Yes.
Tribunal is still there?
Yes.
Records. Please step forward.
Deeply obliged.
Two more orders will pass before the end. Okay, we'll come back at two. Yes, Mr. Hussain.
Yes, my lord. This is my lord, expiry order, my lord. The petitioner did not receive any notice, my lord, from the tribunal, my lord.
Where is the order?
My lord, impugn order at my lord, page 52, my lord.
Is 5-2.
Yes, please.
How you have come to know?
My lord, in the month of, my lord, last part of December 2023, my lord, when I met to the BLO, my lord, who informed me, my lord, that you had declared as a foreigner, my lord. Then, my lord, only I get to know, my lord.
You went to whom?
My lord, BLO, Globe, my lord, I have stated paragraph 11 and 12, my lord. While the petitioner met with the BLO booth level officer, my lord, for getting ration card, my lord, and then, my lord, he could come to know that. But I have also annexed, my lord, the report of process server, my lord. That is page 51, my lord. The very first day, my lord, without my lord, taking other option as per section 3(5), my lord, directly, my lord, the process server paste, my lord, hang the notice. My lord, as on that, my lord, I am residing on the same, at the same place, my lord.
Read.
my lord.
Order 3. 5, subclause 5. And subclause Roman F.
Yes, my lord, as per
Kindly read, kindly read.
if the proceeding has changed the place of residence or place of work without intimation to the investigating agency, the process server shall affix a copy of the notice on the outer door or some other conspicuous part of the house in which the proceeding ordinarily resides or last resided or reportedly resided or personally worked for gain or carries on business, and shall return the original to the foreigner tribunal from which it was issued with a report endorsed thereon or annexed thereto stating that he has so affixed the copy, the circumstances under which he did do, and the name of the address, name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed.
Now, please come to page number 4.
My lord, of my petition, my lord.
Address of the petitioner.
Yes, my lord.
Kindly read.
My lord, Zohar Ali alias Zaraz Pramnik, son of Sanso, village Alamganj part 9.
Hmm.
PO Alamganj, PS Gauripur, district Dhubri, Assam, in so and so.
Now, please come to page number 49. What was the address given?
Alamganj, Novam Khondo.
No, top. Gosor number.
Yes, my lord. Gosan number FT4
Then
oblique
name,
161
then
ZPR.
name.
My lord, Zahar Ali,
Father's name.
son of my lord Zohar Ali. In Assamese, my lord, it is written as
Okay.
Zahar Ali. Father's name is Sattar Ali.
Sattar Paramani. Okay.
Yes, my lord, Pramani.
Then-
But my father's name is Safar Ali, my lord.
Okay.
Safar Ali Pramani.
Then village,
Village Alamganj, Novam Khondo, part 9, my lord.
police station.
Police station, Gauripur.
Now, please come to page number 51.
Yes, my lord.
There is one signatory, Zoinal Abedin Sarkar, Village Defense Party Secretary,
Yes, my lord.
right?
Yes, my lord.
Alamganj, part 9. Now, read the contents, Mohoday.
My lord.
Read the contents. Can you read that
Yes, my
particular?
lord. সম্মানপূর্বক বিনীত নিবেদন এই যে মোতায়ন মতে জাননীত উল্লেখিত স্থানত গৈ মানুহক লগ ধৰি ভোট পোচ কৰি গম পাওঁ যে কোনো জাননী নিদিয়াকৈ সেই স্থান এৰি অন্য ঠাইলৈ গুচি গৈছে, গতিকে জাননীৰ কপি তেওঁৰ শেষ বাসস্থানৰ বেৰত আৰু উপৰোক্ত সাক্ষীজনে দেখুৱাই দিয়া মতে আঠা লগাই জাননী জাৰি কৰি মহামান্য আদালতলৈ প্ৰেৰণ কৰাৰ বাবে
থানাত সমজাই
থানাত
দিয়া
সমজাই
দিলো।
দিলো। Yes, my lord.
Hmm?
Yes,
There is a constable.
my lord. She's a
He has
constable.
read and forwarded it. Where is the illegality?
My lord, I am the resident of that part, my lord. As on that, my lord, I am residing there, my lord. In fact, my lord, no notice has been served, my lord. This notice has been, my lord, shown to be falsely served, my lord. In fact, my lord, I have not, my lord, received any notice, and my lord, since as per servant notice, my lord, process servant notice, it has been written that a notice has been affixed in the wall of the resident last resided, my lord. My lord, as on that, my lord, I have been residing there, my lord, and I have not, my lord, anywhere gone as on that, my lord. And still, my lord, I do not know about the, my lord, status of the case, my lord.
So why do you go there when you are not son of Sattar Ali?
My lord, in FT case, my lord, it is wrongly written as Satar Ali, my lord. But in fact, my lord, my father's name is
Don't bother.
Safar Ali Pramanik, my lord.
Since you are Safar Ali Paramani
My father's name is Safar Ali Pramanik,
and
yes,
it is not there in the notice,
my lord.
don't bother.
Now, my lord, I am not getting the benefit, my lord, due to this case, my lord. That is why, my lord,
Why should you be involved in this case when you are not that son of?
my lord,
Sattar
I have been informed that you have been declared as a foreigner, and that is why I am not getting even ration card, my lord.
So you apply before the authority that you are not the son of Sattar Paramani. Why you are challenging this order?
My lord, since I have been informed that against you.
Yes, Mr. Sharma.
Yes, there is. I think as per section T, order T, fire at lordship, notice was duly served. And lordship, to avoid the trial lordship, the petitioner willingly avoid to accept the notice lordship. Apart from that lordship, if what document petitioner has realized in this petition, lordship will kindly see page 22. This is the previous Bostata part one, Kopi guns. One Bilal Korman name is here. So Buddha Khatim Bibi and Mukram Ali Kormani. Then lordship, page 24, lordship, this is of another village lordship. Yarang Jongla, Yarang Jongla part 3. This is Bilal Kormani name is there lordship. And lordship after that, petitioner father's name, projected father's name first time appeared at Alamganj part 9 in the voter list of 1985 at the age of 24 years. So, lordship, this Safar Paramanic cannot establish his link with the with Bilal Paramanic of 1966 voter list. So, apparently, lordship, there is petitioner could not establish this link with his grandfather lordship. Father and grandfather link is not established.
You are relying on which document?
Lordship, page 22 is the 1966 voter list. Lordship is 96. This is of village Bapkata part 1. Then 24 is the village Yarong Jongla part 3. 1970. Then Lordship, father's name first time appeared in the voter list of 1985 with Lordship Daliman Bibi. And Lordship, this is village Alamganj part 9, that is present village of the petitioner. So, Safar Parmanik cannot establish his link with Bilal Parmanik. His father cannot establish his link with his grandfather of the petitioner. Lordship notice was duly served, and I think Lordship, there is no mirror apparent on the face of the order, Lordship. I leave it to your Lordship. Lordship, order was passed in the year 2018, Lordship. After a lapse of 5 years, Lordship, petitioner approached this honorable court. Initial reference was started in the year 2006.
Heard Mr. A. Hussain, counsel appearing for the petition. And Mr. E. Pegu, Senate counsel. On behalf of Mr. A. Ali, standing counsel election commission of India for the response number 2. Also heard Mr. Z. Sharma, standing counsel Home Department Assam for the response numbers 3, 5, as well as Mr. P. Sharma, additional senior government. Oh, Mr. Hazarika, you were there? Yes. Government advocate Assam. Right. By an expert order dated 27/08/2018, passed by learned member of Finance Tribunal Court, Dhuri, Assam. In case number FT-4/161/ZPR/2018. Declared the petitioner to be a foreigner. Under the Foreigners Act 1946. Foreigner. Not a foreigner, who had illegally entered into territory of India, Assam. After 25/03/1971. Agreed by the said ex parte order. Dated 29/08/2000. 27/08/2018. The petitioner has filed this writ petition on 22/01/2020. Before we proceed further in this process, we propose to peruse the records in the original pertaining to say case number FT 4161 query the landed number of Foreigners Tribunal 4 February on 27/08/2018 passed the ex parte order declaring the petition of from February, when are you getting? Okay, forget it.
Lordship,
Call for the records of
yes, Lordship.
and list on. Twenty-second of February.
Oh, bless me.
What's the day?
May I please, your Lordship? My lord, in this case, my lord, we have two cases against the same petitioner, my lord. Earlier order, my lord, petitioner declared as not a foreigner, is a Indian. That is order dated 5/1/2023, my lord. Well, subsequently, another notice has been issued to the petitioner, and the petitioner appeared before the landed tribunal and filed a WS. And subsequently, my lord, since the order has been passed declaring that the petitioner is not a foreigner in earlier petition, my lord, so petitioner filed a petition along with the order of the earlier order, my lord. But that petition was rejected, my lord. My lord, kindly see page 41, page 41, annexure 7, my lord. This is the order, my lord, passed on 5/1/23, declaring the petitioner as not a foreigner. In paragraph, my lord, the last paragraph of page 41, last paragraph, my lord. The proceeding has pleaded in his written statement as well as his evidence that his name is Abdul Majid and that he was born in Duamari village under PS Laurigat in the district of Nagaon, Assam. His father's name is Nasiruddin and the mother's name is Fulbano. His grandfather's name is Sabed Ali. All the details are same, my lord. Subsequent petition, same. And my lord, kindly see the page 43. Page 43. First paragraph, my lord, thus the proceeding has been able to discharge his burden by adducing reliable and cogent evidence as per mandate of Section 9 of Foreigners Act 1946. Considering the entire material on record and the discussion above, I am of the considered opinion that the proceeding, namely A. Musid, is not a foreigner, illegal migrant in any stream. He is an offspring of Indian parents. But thereafter, the notice issued, my lord, that the notice I have annexed, page 26, annexure P3. Earlier order was passed by Foreigners Tribunal number 2, Nagaon. And the second case, my lord, registered in the Foreigners Court number 9, Nagaon, my lord. That the notice I have annexed at page 26, annexure P3. P and the P28, page 28, the Assamese version, and I have annexed the translated copy. So after getting this notice, my lord, that is FT case number 26/2018. Petitioner appeared and filed WS.
that WS, my lord, page 31, annexer P5. P5 and the particular page 33. Same person, my lord.
No.
The same documents, on the basis of same documents, my lord. And his son also declared as not a foreigner. That judgment I have annexed in page 36, annexer P6. His son also declared as not a foreigner. On the basis of same document, my lord.
Yes, Mr. Sharma.
Lordship, this is not a region order, Lordship. Regarding this honorable court has already settled the law. If there is not a region order passed by the learned tribunal, then res judicata will not apply, Lordship.
Why not the region order?
Because Lordship, in this order, Lordship, learned tribunal only reflects the averments made by the DW1 as well as DW2. And Lordship, after last part, Lordship, I have perused the written statement evidence on record and all exhibited documents very carefully, and it appears that evidence of the proceeding coupled with the documents and appears to be trustworthy, and there is nothing on record to disbelieve him. The proceeding and his father's relationship is well established, and it can be opined that the proceeding succeeded in substantiating his case by oral as well as documentary evidence. I have found sufficient proof on record to come to a definite conclusion that the parent of the proceeding has been residing prior to 1965 in India. Thus, the proceeding has been able to discharge his burden by adducing reliable and cogent evidence as per mandate of Section 9 of the Foreigners Act 1964. Considering the entire materials on record and the discussions of, I am of the considered opinion that the proceeding, namely A. Majid, is not a foreigner, illegal migrant of any stream. He is an offspring of an Indian parents, hence the reference case thus answered in favor of the proceeding. In this case is disposed of on contest, Lordship. Then Lordship will see what documents the proceeding is relying in this
But the
case.
state has not challenged this. It's attained the finality, my lord.
That's not required, Lordship. Lordship, present proceedings resident of Lordship Sarayagi. And he relying on the voter list of 1966 of village Duamari, Lordship, where some Amojit name is appearing at the age of 26 years. And at present, in his affidavit, it is shown that at present proceeding is aged about 88 years, page 17, Lordship. But after 1966, his nowhere his name is existed in the voter list, Lordship. Then subsequent voter list is 1970, Lordship. Here only one Mojit name appeared, Lordship. And see the Lordship, if we compare the 1966 and 1970 voter list, here, Lordship, Mojit.
Abdul
Name.
Majid.
Mojit names appearing. Parents' name is one Nasir, Lordship. And Lordship,
Nasiruddin.
next voter list is of 1970, Lordship, page 20. Here one Mojit's name appeared, Lordship. Parents' name, father's name appeared as Modir, Lordship. There are so many discrepancies, Lordship. By overlooking the all discrepancies, Lordship, tribunal has passed this order, Lordship. So that may be accepted as a valid order, Lordship. That may not be accepted as valid order. So, Lordship, yes.
What is the name of the prosecutor?
Abdul
Majid.
Abdul Majid. And relying on these documents, tribunal has passed the order, Lordship.
Son of
One Nazir.
Nasiruddin. Nasiruddin
Nasir.
alias Nasiruddin Munshi.
subsequent voter list is of only Mojid's is dear lordship and father's name is Modir. And lordship, in subsequent voter list, lordship, um, procedure has to prove that A Mojid of Duamari and A Mojid of Sarahegi are same and one person, lordship.
My lord, it is reflects in the judgment itself, my lord. My lord,
So the court asked you a question.
my lord.
Mr. No,
Yes, lordship.
case 19.
Lordship.
Read from top.
ভোটাৰ তালিকা 1966 চন অসম বিধানসভাৰ 84 নং লাহৰীঘাট সমষ্টি প্ৰদেশ অসম মৌজা লাহৰীঘাট কেন্দ্ৰ নং 93 জিলা নগাঁও
জিলা নগাঁও
গাঁও দোৱামাৰী থানা লাহৰীঘাট
অসম জিলা নগাঁও থানা
লাহৰীঘাট
then মৌজা
মৌজা লাহৰীঘাট গাঁও দোৱামাৰী খণ্ড নং 14 কেন্দ্ৰ নং 93
house number,
হাউচ নাম্বাৰ 13
name of the person,
হামিদ পিতা নাছিৰ আজিত
Pita
পিতা নাছিৰ মজিদ পিতা নাছিৰ সৈয়দ বানু
Janaza Abdul Hamid,
আব্দুল হমিদ আসিয়া খাতুন অজিত জন
right?
ইয়েস লর্ডশিপ
Now down below what you have seen,
এসি ভুয়া ইলেক্টরাল রেজিস্ট্রেশন অফিসার নগাঁও
then
দেন
তিনিজনৰ
প্রমাণিত প্রতিলিপি there is no signature lordship
no, there is a signature.
signature but not
It is them, but in his তিনিজনৰ because the age of the two ladies not there.
yes lordship
That is why it has given 3 persons.
Yeah.
Now come to page number 21.
পা- পাঁচজনৰ-
নিৰ্বাচক তালিকা
yes নির্বাচক তালিকা 1970 চন অসম বিধান লাহৰীঘাট সমষ্টি
প্ৰদেশ অসম
খণ্ড নং 14
জিলা নগাঁও
yes
থানা লাহৰীঘাট
yes
same
yes
then মৌজা লাহৰীঘাট গাঁও দোৱামাৰী গাঁও পঞ্চায়ত is not there. So মৌজা and গাঁও is same.
yes
Now খণ্ড নম্বৰ 14
yes
same. কেন্দ্ৰ নম্বৰ changed. Earlier it was 93, now it is.
it was 83
But to read the name of the person.
no there is no name of the person
Why?
oh Mojid some Mojid name is
Mojid,
Mojid
Hamid is there.
Hmm.
Pita Madir,
yes
right?
yes
Azit is there. Pita
Madir Pita Madir Mojid is there Pita Madir
Huh.
and
Shoaib
here
Banu is also there. Asia Khatun is also there.
yes sir
So this Mojid and Mojid and the present person,
Yes,
because that masjid was there in 1966 as well as in 1970.
Mm.
So only the thing is that
father's name is different,
that may be a printing mistake, we do not know.
maybe, Lord say.
Then 85.
Him Mojit. Ajit, Pita Nasiruddin.
Hmm.
মসজিদ জানাতে বলছেন
Here, one Adul Hai's name is newly entered lordship at the age of 30 years. Pita Nasiruddin.
You're not concerned with that.
Yes, lordship.
So if there is some mistakes, but the name of the other persons remains same, other's name was such changed. Instead of Nasir, it has become
Madiri.
Madir.
Correct, 66 and 85 my lord, same.
After 1985, there is no voter list lordship.
There is voter list, my lord. I have not annexed whole the, because these are not, my lord, at this stage it is not, because case is pending, my lord. What I am on, my lord, I have submitted an application with the copy of the earlier order, my lord. That was not accepted, my lord.
Just a minute.
Up to, my lord, page 42, up to 2019 voter list, Jamabandi. Record is there, my lord.
Record is in system.
Record है ना ये, लोअर कोर्ट को केस पेंडिंग है।
Heard Mr. PCB. Also appearing for the petition. And Mr. Z. Sharma, State Council Home Department and Family Protection number 2 and 3. Also that Mr. Hazarika, Land Government of Assam for the question number 4. As well as Mr. T. Pegu. Land Council on behalf of Mr. A. Ali, Standing Council Election Commission of India, to address for number 6. This petition has been filed by the petitioner on 22/01/2024. Agreed by the orders that is 19/08/2023.
Next, page. Like. আরে উপকারী কথা কয়ে লাভ নাই, নিজে করতে লাগবে। দেওয়া লাগে উপকার
The learned member of Foreigners Tribunal 19 Nagaon. In FP case number 26/2018 initiated against the petitioner. It is the application of the petitioner under section 11. Radio section 151 of the CPC filed by petition number 245. As the petitioner suppressed about the present petitioner counsel up to 09/08/2023. That in another FP case number 777/2011. The Foreigners Tribunal second Nagaon. I ordered it about the other such and such is pending before the Foreigners Tribunal second. And that the same Foreigners Tribunal second Nagaon on 05/01/2023 declared him not to be a foreigner. And the said writ petition, in this present writ petition, petitioner has also challenged the order dated 26/09/2023 passed by learned member of Foreigners Tribunal 9th. The application filed by him under order 8 rule 9 CPC radio section 151 of the CPC. Rejecting for additional written statement. Further, the order dated 2/11/2023. rejecting petitioner's application and rejecting petitioner's petition number 327 for filing additional evidence in said application number. 2000. From the perusal of the written statement of the petitioner, annexed to this petition as Annexure P5.
P5.
Filed on 18/11/2022 we have seen that no petitioner stated about a foreigners tribunal case relating to his son Mustafa Ali, whom the concerned foreigners tribunal on 06/03/2018 declared to be a foreigner. But he did not state about the proceeding of said FT case number 771/2011 pending before the Foreigners Tribunal, Second Nagaon. All for the records of FT case number 771/2011. Disposed of 05/01/2023 from the office of the landed member Foreigners Tribunal, Second Nagaon, as well as the records of FT case number 26/2018 from the office of the landed member Foreigners Tribunal, First Nagaon. List on two zero.
In the meantime, my lord, I have interim prayer, my lord.
But the efforts have been called for, or what do you have to?
My lord.
May I please your lordship? Lordship, this is a contested case, lordship. On the last occasion, lordship, this honorable court directed me to go through the judgment of Central Council for Research in Ayurvedic Science, where lordship, the honorable apex court has laid down the guidelines regarding the issuance of writ of certiorari. Lordship, in this present case, lordship, in that case, lordship, basically, lordship, the honorable apex court has held that lordship jurisdictional correction writ of certiorari can be issued. My lord, in this case, lordship, That is Lordship, item number 37, Lordship. Lordship may kindly come to page number 31. 38, Lordship. Impugned order is there, Lordship. Impugned order dated 31/10/2023. Page number 38, Lordship. May I read the first paragraph? Final order. The reference was forwarded by the competent authority, Superintendent of Police, Sanitpur, Tezpur, Assam, under the Foreigners Act 1946, read with Foreigners Tribunal Order 1964, suspecting the citizenship status of the proceedee. The allegation is that the proceedee, Muhammad Nur Islam Sheikh, alias Nur Islam, had illegally entered into India, Assam, in between the period of 1966 to 71. And forwarded for opinion whether the proceedee is or is not a foreigner of the stream of 1966 to 71. Under the provision of the said act, there appeared sufficient grounds to proceed with notice. And notice was issued to the proceedee to giving an opportunity to show cause regarding this matter. Now, Lordship may kindly come to page number 42.
You have seen that.
The opinion part, Lordship. Here, Lordship, the learned tribunal has held that the petitioner is a foreigner of post 1971. My humble submission is that, Lordship, that is a jurisdictional error. The learned tribunal has exceeded its jurisdiction. And Lordship, regarding that, Lordship, I am relying on some judgment, Lordship, of our good Lordship. May I please, Lordship. Lordship, the first judgment, Lordship, that is Central Council, Lordship. I'm not referring this, Lordship, as because, Lordship, the principal has laid down there, Lordship. It is for jurisdictional error. The second judgment, Lordship, I'm referring to Santosh Das versus the Union of India, 2017, 2 ZLT, page number 1065.
What do you want to show from all these judgments regarding the
Here-
jurisdictional view?
Yes, Lordship.
And
My
what about the
submission,
other case?
other case is, Lordship, Gulapi Begum versus Union of India. Then,
No, the second case, his brother's case. There also the reference is the same.
same Lordship, same. Same Lordship.
That's what we want to know from you.
Yes, Lordship. Page number 37, Lordship, here. Annexer 1, in the second case. Here also, Lordship, the allegation is that the proceedee, Din Islam Sheikh, had illegally entered into Assam
Heard
between.
Mr. M. Ahmed, the counsel appearing for the petitioners. Also heard Mr. Z. Sharma, Standing Counsel, Home Department. For the rest one, number 2. Six and 7. Well as Mr. T. Pegu, Learned Counsel on behalf of Mr. A. Standing Court, the election number 3. We have also heard Learned Government Advocate Assam for the press one, number 5. Both the petitioners are brothers. And son of late Nazu Sheikh, SCIH, alias Nazrul Islam, Udin Beckett Sheikh, alias Nazu JK, of village Suez under Biswanath Police Station, District Biswanath. The petitioners the petitioner of WPC number 162/2024 is agreed with the final order to the 31/10/2023 passed by learned member Fairness Tribunal First, Biswanath Sariyali in BNC/FT in case number BNC/FT/1429/2016, whereby he has been declared to be a foreigner under the Foreigners Act 1946. Holding that he had entered India illegally on or after 25/03/1971. Similarly, in WPC number 175/2024, the petitioner being dissatisfied with the order dated 31/10/2023 passed by learned member Fairness Tribunal Biswanath First in case number BNC/FT/1440/2016. Final order লিখেছে না? একটু লিখেছে তো। Declared him also to be a foreigner under the Foreigners Act 1946. Illegally entered, holding him that he had illegally entered territory of Assam after the cutoff date of 25/03/1971. The petitioners contended that as apparent from the impugn orders dated both the impugn orders dated 31/10/2023 it can be seen that the Superintendent Police Border, Sonitpur, Tezpur, Assam referred the matter to the Foreigners Tribunal so as to determine as to whether they had illegally entered into India, Union Bracket Assam, in between the period of 1966 to 1971. But the Foreigners Tribunal Biswanath First by the impugn final orders dated 31/10/2023 declared both from them to be a foreigner under Foreigners Act 1923 of 25/03/1970 on or after were illegally entered into India liquor after 25/03/1971, thereby exceeded its jurisdiction. Is a notice returnable by writing. Petitioner is of writing. Appear before tribunal on or before 13th. Superintendent Police Border, Biswanath. call for the records. তারা গোটা খালি লিখে দেবো, if not taken to picture. Place this matter for admission immediately on receipt of the relevant records.
Highly obliged.
Maybe. Basically, we are agreed by the order of promotion made in favor of respondent number 3 and 4, which is a clear case of superstition. I am senior to them. And secondly, I filed a writ petition praying for an interim protection matter that was not granted, that was refused.
What is the order of the learned civil judge?
Matter. That the lordship will find at page 71 is the operative part matter. Page 71, lordship's workman.
Just.
Starts from page 70, operative part is at page 71, bottom paragraph number 71.
Just a minute, just.
No.
Urban program officer.
Immediately order.
আপডেট করছে কি দাদা?
और आपके पास कुछ
খবর খবর লাগে মুখ
ना नहीं जाने तो
মুখ করলে কোনো কোন লাগে
ना it is his duty to tell you. तुम्हारी जे लॉर्ड तो की नाम था? की नाम था? की नाम था? की नाम था?
না ফিক্স আমি ইনস্ট্রাকশন নাই
नाम तो नहीं है बोल बस बोल हमने तो मन था सो गांव का ही बोल কি নাম था रे लॉर्ड অরুণ তার পেজে তো মেনশন করেছিল 10:30 10:15 এই কইছে কি ইনস্ট্রাকশন প্লেস করব
How you are affected?
and I'm affected because
In an earlier writ petition
my lord
in Kame Bengia, that order is still there. What happened? Was there any outcome of that writ petition?
no writ petition is pending my lord. In the writ petition my lord, what has happened, respondent number 3 and 4 were fighting between themselves about their seniority, challenging the seniority list of 16/7/2008 in the cadre of UPO. Now, writ petition was dismissed, and in the writ appeal was allowed, and the seniority list of 16/7/2008 was set aside, directing the authority to prepare a fresh select list. Then the respondent went before the Honorable Supreme Court. Supreme Court has passed an order which your lordship will find at page, my lord.
67.
67, lordship may kindly see. Supreme Court has passed an order of status quo.
But it was ultimately,
Thereafter, they have promoted one of them, officiating promotion. Then the Honorable Supreme Court said, no, you should not do all these things. You should do if you want to make some order, you should take page 77, Lordship will kindly see. You can do so only after seeking permission from the Supreme Court. Page 77, my lord. Lordship will kindly see the third paragraph. If any future appointment, I am reading from the above paragraph. It is most respectfully submitted that in view of the order of status quo dated for
Page 77.
page 77, madam. Lordship has got my page 77. Second paragraph. It is most respectfully submitted that in view of the order of status quo dated 8/4/2016 passed by this honorable court, the government is withdrawing the office order number so and so 15/6/2020 by which so and so executive engineer was promoted to the post of superintending engineer on officiating basis. Thereafter, if any future appointment is to be made to this said post in the exigencies of administration during the pendency of the civil appeal, the government will do so after seeking the permission of this honorable court. Mr. So-and-so learned counsel appearing on behalf of the state Arunachal Pradesh stated that the order appointing the appellant in the civil appeal on so-and-so officiating basis as superintending engineer has been withdrawn. Since the grievance of the contempt petition arose out of the grant of officiating promotion to the appellant in the civil appeal and the order has since been withdrawn, it is not expedient in the interest of justice to pursue the contempt proceeding further. Thereafter, my lord, what has happened? Now the respondent, to get rid of the entire problem, promoted both of them. Now, both of them are junior to me. Personally, kindly see page 51. They were fighting between themselves. Now, to solve their problem, both of them were fighting without thinking that I am a senior person, I'll be affected. Page 51, my lord. The serial persons at serial number 6 and 7, or should you kindly see, are those two persons who were fighting, my lord. I am at serial number 11.
Page
51, my lord. I am reading from the top, my lord. Order. On the basis of the recommendation of the Departmental Promotion Committee Board, the service of the following deputy directors on officiating basis are hereby regularized with retrospective effect from the date of attaining the qualifying period of service as per the recruitment rules as indicated below. 6 and 7 are the respondent number 3 and 4 here in my lord. And 11 is the present appellant before your lordship. Lordship, kindly see the date of regularization. 21/8/2009 is the date of regularization of respondent number 3 and 4. And 14/8/2009 is the date of regulation of the appellant.
Just a minute. And the respondents.
And the
serial number,
serial number 6 and 7, my lord.
2 and 3.
Yes.
No, Ramoeli is the appellant, I believe.
Appellant before your lordship. Appellant is senior because his date of regulation is 14th of August. And their date of regulation is 21st August. Page 51, my lord.
What is the order?
Order of what, my lord?
The simple order you are challenged.
Yes. That your lordship will find at page 45, my lord. Page 45, dated 2nd of December 2023. In the interest of public service, the Governor of Arunachal Pradesh is pleased to allow the following executive engineers to officiate and look after the charge of superintending engineer under the Urban Development Department in the respective scale of pay and allowance to ease the workload. This is purely on an interim arrangement considering the exigency of service till the outcome of DPC. Further, the Governor of Arunachal Pradesh is pleased to order the transfer and posting of these officers in the
Where is the
places.
name of the persons?
Yes.
In this list, it is not there. Page 52.
My lord, these are the two persons, Sri Rokpo Tamin and Himar Ete. These are the two names is slightly different, but these are the two persons. my lord.
Imarete.
Himar Ete and Rokpo Tamin is the other respondent. I was also confused and they clarified that same person.
Imarete.
Himar Ete and Rokpotamine.
RD Levy is Rokpotamine.
RD Levy is actually Rokpotamine, same name, same person. There is no dispute about this. That's same.
Roccotamine,
Yes,
serial number?
his position in page 51 is serial number 7 and Himarete is 6,
No, page 50.
51. In the,
Oh,
in
51
the,
and 52 are different.
no, madam, same person,
No, persons are same.
madam.
List is different.
No, page 51 is the date of regulation in the post from where they have been promoted
That's what I'm
now.
asking you in 51,
Madam,
serial number 10 is Himarete. That's
No.
what you've been,
no, madam, at page 51, serial number 6 and 7 are Himarete and RD Levy. Lordship has got my page
somehow
51.
you have, there is a typing mistake in the serial numbers of page 52. I'm looking at page 52.
Oh,
Himarete is a thing. Take it.
not ठीक है. So, yes, madam. Typing mistake. No, there is some typing mistake. Actually, actual order is at page 18, Lordship may kindly see. It's a typed copy. Lordship may kindly ignore that. Page 51 is the original copy,
Page 51.
my lord. It's a typed
And
copy.
then
6 and 7 are the two private respondents. Their date of regularization is 21st of August 2009. Serial number 11 is the appellant before Lordship. His date of regulation is 14th of August 2009.
6 and RD 11 is the same person.
Same person, same person.
RD Levy is Rokpotamine.
Is Rokpotamine, same person, man.
Serial number 7 and serial number 3. Mr. Muzumdar,
My lord,
you are saying that their date of regularization is,
21st of August.
whereas that of the writ petitioner was 14th of August.
Yes.
Yes.
So now what has happened, my lord? Thinking that they cannot challenge my seniority, both of them have filed a writ petition challenging my initial appointment made in 2002, now in 2023. And in that case, my lord, they have obtained an order of status quo. And then I appeared and filed an application for a modification, which you will find at page 37, madam. That interim order was modified. So will kindly turn to page 37. Page 37, madam. Page 37, I'm reading from page para 2, madam. By this interlocutory application, the applicant, who is the private respondent number 6 in WPC
Just a
number,
minute, just a minute. You have shown us page 51,
my lord.
but what about page 53?
Page 53 is the, my lord, date, Lordship will kindly say, on the recommendation of the committee constituted so and so, the final interstate senatorial list of UPO, this is the rank below the present one, my lord, UPO. Their position was 6 and 7, they were fighting, my position was 12. Two things are there, my lord. First of all, this gradation list has been set aside by the Honorable Division Bench here. They have gone to the Supreme Court, that is pending.
This one.
This one. Secondly, my lord, I am senior in the rank above that. Lordship, page 51 is this regulation in the post of Deputy Director, which is equivalent to Executive Engineer, my lord. And from there, the next promotion to the Superintendent is given to both of them. Here I am senior because my regulation was from the date of my officiating.
In the writ petition filed by
These two respondents, my lord.
the, respond number 3, Rocco W, that is,
Yes, there was a status quo order.
No, single bench passed an order.
Passed of status quo order.
Division bench passed an order.
No, single bench, my lord. They have filed a writ petition
Hmm.
challenging my appointment itself, made in 2002. In that writ petition, there was an order of status quo. Now, page 37 is the order where I came to know that there is a status quo order against me. I filed an application for modification.
The division bench passed an order setting aside that order
No, my lord.
of page 58, right? 53.
My lord, division bench passed the order in the writ
Page
petition.
53.
My lord,
Come to page 66.
66, yes. Yes. My lord, this writ petition is different. This writ petition which,
No.
No.
We want to know something from it.
my lord,
This order at page 53 has been set aside.
yes.
And
And the direction was there at
issued to
page
issue a fresh final senior release of UPOs.
UPOs.
Now,
That is challenged in the Supreme Court.
that is challenged in the Supreme Court.
Then there is a status quo order.
Then there is a order of
Status
status quo.
My lord,
But
my lord,
this order
my lord.
of Urban Development Department promoting you from 14/8/2009
My lord,
and similar order by which the respondents were promoted from 28/07, 0
My lord.
August,
my lord.
whether under challenge?
No,
It is not under
not
challenge.
what I'm telling.
Now matter relates to the proposed
Promotion,
on
further
the
promotion.
officiating basis.
In fact, there was no proposal for further promotion when both of them are fighting for the seniority between themselves. In order to get rid of the whole problem, the government promoted both of them. Of course, it's an officiating promotion. But in the process, they have ignored that a person who is senior to both of them has been superseded.
Now you have filed a writ petition for what?
The present petition I have filed challenging the officiating promotion made, which your lordship will find at page 45. Ignoring the fact that I am senior
You
to
are-
both.
Since the respondent authorities ignored your seniority and recommended them for officiating promotion.
Yes, man, not recommended, my lord, they have
They are promoted.
given officiating promotion, yes.
So you have challenged this order of 2nd of December.
Yes, man,
2023.
in the present writ petition.
Now, what was the order passed?
That is what I'm showing, man. That your lordship will find at page, starts from page 70. Operative part at page 71. I prayed for an interim order. This is how the interim order was dealt with, my lord. Page 71, the last paragraph.
No, we want to know what is the other writ petition, WPC 374/2023,
My lord, 374 is,
because another person,
my lord, in the 374,
there is also another person who
Ma-
was promoted from 14th of August 2009. He is coming.
Kame Bangia, yes.
He is also from 14th of August, just like you.
Yes, my lord.
What happened there?
That is what I'm saying, my lord, that in that case, page 37, lordship will get that order, my lord. This is what I wanted to show, my lord. There was an order of status quo obtained by that Kame Bangia.
Hmm.
That order has been modified by an order of 4/10/2023 at page 37. Page 37, my lord.
Just a minute.
আমার মূল নাম পার্থ মোহাম্মদ। আর ওখানে তো নতুন তিনটে লিখতে হবে। হুম। হুম। Technical সমস্ত দিক আছে, আপনি দেখুন দেখতে পাচ্ছেন। They have challenged my degree, my lord. Page 39, lordship will find.
No, that order of status quo has been modified.
Modified. Modified to the extent that ex parte interim order registration is modified. And then next paragraph, lordship, next paragraph, at page 39, para 6. Accordingly, it is provided that the process of selection to the post of superintending engineer may be done and result of such selection be kept in sealed cover without publication, and further, the selection so made shall be subject to the final outcome in the WBC number 374. That was the order passed on 4/10/2023.
Hmm.
And then on 2/12/2023, ignoring all these things, is officially promotion has been passed, saying that it is an interim management. Could that be done, madam?
The 2nd December order is under challenge.
My lord, my lord. That I challenge before the honorable single judge, and the honorable single judge says, which is, lordship will find at page 71. It is made clear that there shall be no bar on the respondents to process for preparing seniority list of the post of executive engineer and selection to the post of superintendent engineer, basing on such seniority list to be prepared. However, the result of such selection, if made, be kept in seal cover without publication as provided in the order just so and so, wherein it is further ordered that the selection so made shall be subject to the final outcome of WBC number 374. I am agreed by that, man.
Why?
Page 71.
71 and 72.
Yes, man.
Same,
Yes,
if you read this order,
yes, more or less same. So what I am saying is, my lord, they could not have passed the order of promotion either in official capacity or otherwise. Now, this from the court prevents something you
where is
do
your
in a
writ
different.
petition?
My lord,
Where is your writ petition?
that your lordship will find at page
Page 18.
18, my lord.
1/8.
1/8.
What was your prayer?
Lordship will kindly, sir. Page 31 is the prayer, my lord. Page 31 is to quash that order of 2/12/23, and page 33 is the interim prayer. Page 33, my lord. In the interim pending disposal of rule, this honorable court may be pleased to stay the impugned officiating promotion from 2/12/23 issued by the Commissioner Urban Affairs, etc. my lord. They don't have a least regard for the order of passed by the honorable court, my lord.
Yes, Mr. Chaudhary.
Yes, sir. Some instruction, my lord. I need some time to find the affidavit, no?
Maybe, but
Yes,
it is
your
a,
lordship, kindly go to the please, my lord. Now, my lord, provisional select list has been published, my lord.
provisional will not do.
Yes, ma'am.
Direction of the court is very specific, no?
Yes.
Then
Kindly come to the.
wait a minute.
Yes, my lord. Your lordship, kindly come to the address to me, my lord. And I'm not secretary, my lord. And directly be involved, this is 40 of the license, sense of details of terabyte 1 and for law of taking for some time. Therefore, you request to pay over court for preparing terabytes comment and finally affidavit. Then I received this matter on the basis of record provided ED and housing secretary in view of the case claiming the.
See, Mr. Chaudhary, you are fully aware, right? This particular finding with regard to the date of regularization
Page
as an
51.
executive engineer is not under challenge anyway at page 51.
I have to take instruction.
That-
No, petition of instruction is not there at this
That is
stage.
the issue, my lord. It's a-
Now, if this is, this particular order at page 51,
On the basis of recommendation, departmental commission committee, the service of the following deputy director, officiating this is how we are by regular prospective the service committee. Taking again independent.
the date of regularization is 14/8.
14.
Whether
Of
it
the-
was challenge or not, my lord, that.
Okay, now this is not under stay at this moment.
No, my lord.
Since it is not stay, there was a challenge with regard to the educational qualification of the petitioner,
Yes, my lord.
wherein the court specifically observed that
Status.
selection will go on,
Yes, my lord.
but it will be kept in seal
Seal.
cover.
Still,
Now, that was an order of October 2023, right? In December 2023, you have promoted these two persons on officiating basis. You have promoted these two persons on officiating basis,
Yes, sir.
but that as an executive engineer, date of their regularization is after the present writ petitioner as well as the petitioner of the said writ petition, right?
But my position is something different, my lord.
How can it be, how you can alter?
Yes, my lord. I have to take the instruction. Why it is because of the kindly come to give my lord that instruction I have received.
That we have
Am I
seen.
at the date of appointment 14/8/2009?
No, it is, that is the reason we are telling you. Have you passed any order correcting date of regularization?
Yes, my lord.
If you have not passed any order
Yes.
correcting the date of
Yes, my
regularization,
lord.
it was issued in June 2011.
Yes, my lord.
How at this stage you can come back? Apparently, the petitioner as well as the other writ petitioner
Yes.
of, his name is
Kame Bangian.
he is senior to these two persons. You have not only considered the case of the petitioner, you have
And it is
also
their
not
order, my
considered also him,
It is their order.
right?
Whether it was challenge or not.
No, no,
That is.
That is a different issue,
That's a
Mr.
different-
Chaudhary. As on 2011, at page order 51. The petitioner is senior to the present two respondents, private respondents.
As per that letter, senior, my lord, as per letter I received by lord. Your lordship kindly come to my lord. Because but I do not know whether that particular order have your lordship shown me. That was whether challenge or not, that instruction is not available with me. As on today, my lord. So lordship kindly come to that, my lord. Date of appointment of the Hamariti, my lord, 14/8/2009. Date of appointment of Akpotami, 14/8/2009. And my lord, Ramu Wali is 14/8/2009.
Hmm.
My lord,
Has it been corrected?
maybe, my lord, it was maybe
How can it be? This is a provisional list.
Yes, my lord. So.
Till then, till then,
I am not, I am not receiving any instruction. I wrote a letter to my lord.
there is no date, nothing. Anyway,
An order of regulation, can it be discharged by a subsequent order of provisional agency, which is unheard of, my lord? A provisional list you are preparing, ignoring your own order of regulation, giving specifically the date when which, since which.
Nine, my lord. I think one is,
Page 51.
heard Mr. D. Muzumdar, Lanet Senior Counsel. Assisted by whom? Lanet Counsel for the appellant. Also heard Mr. NNB Chaudhary, Lanet. Additional Advocate General,
My lord.
Arunachal Pradesh. For the responding numbers 1 and 2. By an order dated 18/06/2011 under number DUD oblique establishment or ESTT, E capital, dash 389 oblique 2007-08. The government of Arunachal Pradesh in the Urban Development Department on the recommendation of the Departmental Promotion Committee Board, regularized the service of the appellant Ramu Ali as deputy director with effect from 14/08/2009 and that of respondent numbers 3 and 4 with effect from 21/08/2009. It is to be noted herein that one Kame Bengi filed a writ petition being WPC number 374/2023 against the present appellant regarding his qualification for his selection to the post of superintendent engineer in the Department of Urban Development and Housing, Government of Arunachal Pradesh. And date of regularization as Deputy Director of Urban Development Department of Arunachal Pradesh in terms of the said order dated 18/06/2011 of said Kame Bengi is also 14/08/2009. The respondent number three filed a writ petition against the respondent number filed, no, the opposite, no, three, filed writ petition WPC number 272/2008, which was dismissed on 04/11/2003, against which the respondent number 3 preferred a reappeal, being writ appeal number 05 within bracket AP 2014, wherein a division bench by judgment and order dated 28/01/2016 set aside the final seniority list of Mr. Mazumdar. UPO means
Page 16/7.
no, UPO means some officer, key officer. What is the rank? UPO means
Urban Program Officer.
urban program officer.
Right.
And the concerned state respondents were directed to issue a fresh final seniority list of QPOs, placing said Rockpo W above either respondent number 3, above the respondent number 4, Himarete. And the said matter is presently pending before the Honorable Supreme Court as being challenged by the respondent number 4.
One thing is that, my lord, single the judgment was not challenged, my lord. So, my lord, my humble submission.
We are not on that. We are not on
And
that.
my submission,
That is not relevant here.
We are saying something else.
it shall be
In the
remanded.
meanwhile,
Hmm.
in said
Hmm.
WPC number 374/2023, wherein the present appellant is the private respondent. An order was passed on 16/08/2023, wherein the respondent authorities in the Urban Development and Housing Department were directed to maintain status quo on the process of selection to the post of superintendent engineer in the same department. However, in an interlocutory application filed by the present appellant in said WPC number 374/2023 being IA within bracket C number 149/2023 on 04/10/2023 said order dated 16/08/2023 passed in WPC number 374 within bracket AP 2023 was modified as follows. There are 6. Side door 6 page number 13 mark for us. In the meanwhile, the state government in the Urban Development and Housing Department by an order number SUDH /15/2023 SUDH UDH /459 dated 02/12/2023 allowed both the respondent numbers 3 and 4 the executive engineers to officiate and look after the charge of superintending engineer civil under the same department in their respective scale of pay and allowances to ease the workload, observing that the same is purely an interim arrangement, considering the exigencies of service till the outcome of departmental promotion committee. The present appellant, being agreed with the said order dated 02/12/2023 passed by the authorities of the Urban Development and Housing Department of Arunachal Pradesh, filed a writ petition being WPC number 607 within bracket AP/2023, challenging the legality and validity of the said impugned order number such and such and such provided. stating that he is senior to both the private respondents as he was considered his service as deputy director was regularized with effect from 14/08/2009, whereas that of the respondent was such and such. And therefore, comma dear, which is not under challenge. And therefore, the respondent authorities prior to considering the case of the respondents number 3 and 4 for their officiating promotion as executive engineer should have considered his case. In the said date petition number such and such WPC such and such. The present appellant as petitioner prayed amongst others for setting aside and quash the said order number dated such and such, and also prayed for an interim order to stay the said order, if it's a promotion order, it is 02 officiating promotion of the restaurant number 3 and 4. Dated 0-12/2023, issued by the Commissioner, Urban Affairs, Urban Development. Such and such. It is submitted by Mr. Majumdar, Learned Counsel, appearing for the appellant, that while issuing notice to the respondents in said WPC number 607/2023, the Honorable Single Judge by order 15/12/2023 in the interim observed that is 71. Without considering the interim prayer failed to pass any such ordering to that extent, in spite of observing the fact that the state government in the such and such department before the Honorable Supreme Court in contempt petition C number 472/2020 arising out of civil appeal number 3794/2016. Didn't look at the figure. Arising out of judgment and order. A division by Mr. Majumdar,
My lord.
that civil appeal that is pending before the Supreme Court,
Yes, number, my lord.
3794/2016 relates to the Order dated 28th of January 2016, passed in writ appeal number 05/2014, I believe,
My lord.
right?
Yes.
Relates to. His husband in order the 28/01/2016. Passed in writ appeal number 05, originally KTP 2017, noted earlier. And the order is the 05/11/2020 Honorable Apex Court. At Baratu. Clearly observe that page number 77. Hence this writ appeal. It is contended by Mr. Mazumdar that while promoting the respond numbers 3 and 4 to the post of executive engineer in Urban Systems Department by the impune order in the Texas. The state government did not obtain any prior permission of the Honorable Supreme Court. Has been recorded by the Honorable Supreme Court in its said order dated 05/11/2020. And the Honorable Single Judge, the Honorable Single Judge failed to consider of that aspect of the order and did not pass the interim order as prayed for in WPC number 7. You can read petition. So notice returnable by. There is a division bench in the. Why should we keep it here?
Presently, I think now regularly the division bench is there, almost
Yeah.
regular.
So any bench without Kadak and Budi Habung, right?
Yes, yes, both of them cannot take
It
it.
can be transferred back. No, that is the reason we are saying. Next week also there is. Why should we entertain here?
Or she may send it back. At that time, it was not there.
But we would have sent it back immediately.
Lordship may pass the interim order, then send back, then can be taken up at an early date for disposal. At that time, at the
Should
time,
not be interfered.
no, my
Proper
lord, at
division
the
bench is
time
there.
when this transfer was made, my lord, we immediately, because continuously the division bench with Kardagate was there, Majestic Kardagate. So that is why we had to file the application for transfer. Now, the lordship, after passing the interim order, lordship gets on 2 dates it came before the lordship.
Just a minute.
Single bench order was not. The interim order. And it's next to the 40 2009, I have no instruction whether it was 17.
Allowed till the state of admission.
This is the practice, your lordship passes this order here, then transfers him.
And you also may directly dispose of the matter within a week, or 2 weeks.
No, not without parliament. Otherwise, where is the point of transferring the case from there to here and moving the application here, appeal here?
This education and qualification.
And my learned friend is not holding the brief of the
Mr.
private respondents. He is-
Mr. Chaudhary, it is the department who submitted before the Supreme Court, right? That they will take prior permission. If you can show that prior permission was obtained from the Supreme
fine.
Court, fine. But if there is no such prior permission from the Supreme Court, I think you could not have, you have committed it. You should go for contempt now. It will be like contempt order. You will be in trouble, I'm telling you, Mr. Chaudhary. When you have made a submission before the Honorable Apex Court, that also by filing an affidavit, that prior making any such appointment in exigencies of service, you'll obtain prior permission.
78.
And how you have done that, we do not know, because the order doesn't reflect that after obtaining permission from the Supreme
No,
Court,
no
you
permission.
have done that.
And we made a specific
You'll be in
statement.
trouble, I'm telling you. Once it is brought to the, by any of the parties brought to the notice of the Supreme Court, what will be your happen? Not yes or no, you know the consequence. That's unfair on your part. The order it is 02/12/2023. Passed by the Commissioner, Urban Affairs, promoting both the respondents number 4 and 5, it is 3 and 4. On a visiting basis to the post of superintendent engineer civil. Is also without any permission from the Honorable Supreme Court, as we have perused. What's it? It's a notice. 4 weeks go to the appellant shall text such and such and such. The interim order. The impugn order it is such and such and such. The state until further order. In the interim period.
Method of transfer.
Two directions.
Madam, deeply operating.
Take steps
Madam, I'll take steps.
within 2 days.
Method of
We
transfer.
talk
By
only
tomorrow
respond number 1 and 2 on by NNB order.
Sure.
3 and 4 by registered proceeding. Now, by dusty service query, the same person. They have to file an affidavit.
Madam,
Method of transfer will be here. Transfer by the.
We cannot, there is a reason.
Yes, yes.
The Honorable Chief Justice acting in his
Yes, yes.
Madam, we filed a
administration
formal application for transfer.
now have passed an order saying that allowed till the stage of admission only. Thereafter, the matter be records be sent back to the Itanagar bench. So we have issued notice in this appeal.
Let them come.
So once it is admitted at that stage, we can do it.
Oblige.
Whatever.
If it may be taken on
Ah.
fifth, my lord, Monday next,
Not on tomorrow, not
Fifth.
on,
Monday.
because not on Monday or Wednesday.
Then Tuesday, my lord, on sixth.
Before that, we possibly.
Let us see how many items we have on.
Earlier, possible, this matter, earlier opinion, that was not listed.
Just. Eight.
Eight, Mr. Mishra has some difficulty. Eight and ninth,
Sixth,
sixth month,
2nd February, Friday. We do not. Sixth,
sixth.
Top of the list.
that we cannot make a mention in the morning.
May I please, your lordship?
What is make a mention in the morning?
May I please, your lordship? Your lordship, I have a small prayer, your lordship. Item number 36, your lordship, we have listed it matter by order, your lordship, item number 36. Your lordship, in the first week of February or second week of February,
Matter about
Hearing your lordship, foreigner, your lordship.
The proceeding is in custody.
No, your lordship, actually, the petitioner's son, your lordship, he has cleared the NEET examination medical, but he is not able to get his campusing, your lordship, because he is not getting the PRC because of his father's FT case, your lordship.
Sixth.
6th of April. Oblige, your lordship.
Hearing item.